Good morning, everyone. I had a discussion with Council in Chambers this morning as to the planning. We will have evidence presented on victim impact statements. There are probation officers, social workers that are here that will testify. Then at some stage we will go live on a video link with a witness that will be testifying from the United States. Thereafter, I believe that Mr. Van Reyns, a family member, will testify. And thereafter we'll deal with the arguments. Hopefully between today and tomorrow we can complete that process so that we can finalize the matter on Thursday. That's the current planning. Thank you, Ms. Swanepoel.
My Lord, as indicated in Chambers, I think we will start off with the probation officers' reports that have been requested by the court.
They are witnesses that are actually court witnesses, but as is customary, I'm going to ask the prosecutor to lead the witnesses. Do you know who the officials are that are here?
Mr. Peterson, my Lord, Errol Peterson.
He will be presenting.
My Lord, if I understand the position correctly, he actually drafted all three the reports.
Yeah.
Mr. Peterson. So I'm of the view that there's only one witness. I have not seen him.
I believe that he is here.
Mr. Peterson, Errol Peterson.
I was told this morning that the social workers arrived and
My Lord, I'm told that apparently there was some correction to be done and he left. Can I throw over the whole apple cart and suggest that we start with Dr. van der Walt? He is available. He has indicated that he is online. Left. The social worker has left, my Lord. I believe that he will be returning. If it's possible, can we perhaps...
It's unacceptable. I told Council in Chambers this morning what happened on Saturday past. The requests for the reports were sent. We had an undertaking that the reports would have been available 4 days prior to today. That meant it would have been available on Friday the 23rd. When it didn't arrive, it was my registrar followed it up via email, only to be told on Saturday afternoon that they want a postponement. The Department of Social Development. I intervened. And after some threatening emails by my registrar, all hands came on deck and the reports were available yesterday. But this is not the way it should be done, and I take it the supervisors and the heads of that department who were all copied in on the email of Saturday afternoon and the operations over the last weekend take note that this is the way officials act and deal with the courts. And action must be taken. So, are we ready to link in with Dr. Van der Walt? Can I just... You've already joined me. I'm
That's
on.
okay.
So how are we going to do it? Are you going to project it on the big screen?
I am going to try to do that, my lord.
If I can't see anybody else that's on the platform, I see myself and Avat is in, it still says there must be a request to join. There he joins.
My lord, I did communicate to him to say that we would probably get to him by 11, so I'm glad to hear that he's still there and hasn't left, that he's still online.
I
I'm
can
just
see
also
him on
trying
my
to-
screen.
Thank you, my lord.
Good morning, my lord.
Good morning, Mr. Van der Walt, Dr. Van der Walt, I apologize. Are we going to project it onto the bigger screen, Ms. Swanepoel?
We're going to try that, my lord.
Just bear with us for a moment, Dr. Van der Walt. What time do you have it where you are? I see you're based in DC.
That's correct, my lord.
So is it 20 to 7 in the morning? I mean, 20 to 4 in the morning.
That's correct. 24.
It's hanging. It's hanging.
All right.
I'm sorry, my lord. This is Murphy's Law. Now the PC is just hanging. It's just doing nothing. I'm trying my best. Please bear with me. Can you find your teams?
Well, there's maybe another way to do it. Oh, there we go. Just want to get Ms. Swanepoel to join the team. Are you going to be long, Miss Honorable? I'm admitting you.
Thank you, my Lord.
All right, you can see it on the screen. We've already started the recording. May I have your full names for the record, please?
Dr. van der Walt, can you hear us? Oh, there's an echo.
Wonderful, I can hear you and Judge Erasmus. Perfect. Wow.
Can you just repeat your full names for the record, please?
Sure, my Lord. It's Marcel van der Walt.
Any objection in taking the oath?
No, my Lord.
You will then swear the evidence you will give will be the truth, the whole truth, and nothing but the truth. Just say, so help me God.
Yes, my Lord.
Thank you. The witness is sworn in. I'm going to mute my own microphone on the laptop. Thank you.
As the court pleases, my Lord. Thank you. Dr. van der Walt, for record purposes, can you please state your qualifications as well as your experience?
Sure. I have a PhD in criminal justice. I have a PhD in justice. The main focus of that study was the investigation of trafficking persons for the purpose of sexual exploitation, and also have a master's degree in forensic investigation, which revolved around the issue of serial rape in South Africa. I've also been a member of the South African Police Service for 10 years, and that followed 10 years in academia, where my research focused on violence against children, missing persons, missing children, and sex trafficking, and obviously the interweaving of these phenomena with organized crime, and that's the focus of work.
Just one moment. What is the problem? Do we maybe have a microphone that I can put it at my speaker to amplify? Because the one that you use there is too soft. Apparently people can't hear.
My Lord, I know that on the previous occasions we used Mr. Harams as speaker. I don't know if he perhaps has his...
We also don't want to create unnecessary feedback.
How did we do this first?
Let's try again. All right. Let's. Okay, Ms. Honorable, you may proceed. Let's see.
Thank you. Thank you, my Lord. Dr. Van der Walt, we apologize for this. We're just trying to sort out the sound.
Noted. It's wonderful. Thank you.
That's better. I've turned down the sound on my laptop.
Thank you, my lord.
Thank you.
Now, Dr. Van der Walt, I know you have tried to answer this question now. I hope that we got it and that it was recorded. But
I am recording on the Teams platform.
Thank you, my lord.
That's integrated with our own internal recording for the record.
Thank you, my lord. If I
Because
may,
it's done on the judiciary platform.
Thank you, my lord. Seeing that you are an expert witness, it is so. Can you confirm that you have also provided this court with a report and also a comprehensive curriculum vitae?
That's correct, my lord.
Now, Doctor, in relation to your expertise in the field of trafficking in persons, just give us an idea, how long have you, in time-wise, how long have you been involved with trafficking in persons, and specifically the investigation as well as the research and in the academia thereof?
Sure. So it's been a period of 23 years from several different perspectives. It started off in frontline law enforcement, investigating with the Family Violence, Child Protection, Sexual Offences Unit, that, as well as the Hawks. That was for a period of 10 years, again, where my work focused on investigations into these phenomena across South Africa, really. And that was followed with a 10-year career in academia. That's where I completed my tertiary qualifications in research. Again, the focus on organized crime, sex trafficking, violence against women and children. And in tandem with that was my work with the National Freedom Network, where I was the case manager for a period of at least 10 years, but over a period of 12 years, received, managed, and or investigated probably in the region of about 900 reports and related reports to trafficking in persons. And then after leaving academia and the National Freedom Network, my work currently in the United States really focuses on the web of sexual exploitation. It's just kind of an augmentation of what I've done previously in South Africa.
And your current position is?
I will refer to two. I do hold a research fellowship at the University of the Free State Center for Human Rights in Bloemfontein. I am also the president of the National Center on Sexual Exploitation here in Washington, D.C. And I may add, also just a council member, active council member of the South African Professional Society Against the Abuse of Children.
Now, as I indicated, you were specifically requested to, in this instance, provide this court with a report, an expert report on trafficking in persons, and more specifically, to assist this honorable court in coming to an appropriate sentence on the trafficking in persons.
Listen, goodbye. Yeah, I've just asked them to shift the microphone with Advocate Swanepoel so that in the room it's amplified slightly more, or she has to speak closer to the microphone.
It's just too high. Thank you, my lord. I think that would be better. I think it was just too high. My apologies. I'm just going to repeat that. Doctor, you were requested to provide an expert report for this court for the purposes of coming to a just and appropriate sentence in this matter. Can you confirm that?
I can confirm that, yes, my lord.
Right. And you did, in fact, draft such a report. The report itself consists of 28 pages, which includes the bibliography at the end. And then there are Annexure A and Annexure B there too. Annexure Annexure A is 2 pages, Annexure B is 5 pages.
That's correct, my lord. There is an Annexure C that there's just a difference between B and C. Annexure B relates to, let's check here. Annexure C relates to sentencing selected cases of adult trafficking cases, and Annexure B relates specifically to child trafficking cases. Hello, yeah.
My apologies. You are indeed correct. Annexure C is from page 4 to 5. My apologies. So Annexure B is only from 1 to 3. Okay.
So it will be Exhibit double R.
As the court pleases, my lord. Now, I want to beforehand just thank you first, Doctor, and that is for the comprehensive report that you had drafted in a very short time span, because you really did not have lots of time to do this. So thank you very much. We are indebted and we really appreciate your work done.
I'm honored. It's really a privilege, so I'm honored. Thank you, my lord.
Having said that, I've gone through this report a number of times, and there's nothing that I think can actually be excluded to say it's not appropriate or not relevant to deal with it. I will therefore, with the leave of the court, request you to deal with your report, to go through your report as you had drafted it for us. I think that would flow chronologically. I'm not going to ask you to go further than your report itself, because all of this will be an exhibit before court.
Yeah.
So I'm going to ask you to just go up to page 22.
He can start from, because he's already given us the his own background, but for purposes of completeness, we can start from item 2,
Yes.
which is to be found on page 3 thereof, the information sources, and then we go on to the global and local overview. And
Thank you, Mark.
And then we can carry through.
Thank you, Mark.
I've confirmed this morning with council that everybody received the report beforehand. So, Doctor, you may proceed and you can read it into the record. And if you want to pause and comment on a particular aspect, feel free to do so.
Please. Thank you, my lord. Thank you, Doctor.
Thank you, my lord. Just to confirm, my lord, that I understood that correctly, I will start reading the report, and I will pause at relevant places, and I will start at information sources on page 3. Is that correct?
That's so.
Indeed.
Thank you.
Great. Okay. I will proceed at information sources on page 3. Just a question, shall I read the opening paragraph or just the sources consulted, my lord?
Read the opening paragraph, I think.
Sure. Okay. I will proceed accordingly. This report is based on 23 years of professional experience in addressing trafficking in persons, organized crime, and the web of sexual exploitation, and encompasses roles in law enforcement, criminal investigation, expert court testimony, academia, and both local and international research. My background includes extensive experience South African Police Services Directorate for Priority Crime Investigations, or the Hawks, the Family Violence and Child Protection and Sexual Offences Unit, and the SABC Hostage Negotiation Team. Post the police, South African Police Services, and between October 2011 and August 2024, I've managed, investigated, or consulted in over 900 information intelligence reports related to trafficking in persons and other forms of exploitation received from informants and the general public. The analysis presented here is further substantiated by academic contributions, including a PhD study, peer-reviewed publications, and presentations at both local and international conferences, including keynote addresses. Additionally, this report incorporates insights gained from numerous interviews and field engagements with active and sentenced traffickers, pimps, and members of organized criminal networks. Collaboration with global anti-trafficking organizations and national task teams has further deepened my systemic understanding of trafficking in persons. I submit that this collective experience provides a robust foundation for the findings and conclusions presented in this report. A comprehensive CV detailing these qualifications is included as an attachment to this report. The following information sources were also consulted specifically in preparation of this report. These include, amongst others, telephonic and email conversations with Advocate Zelda Swanepoel, telephonic and email conversations with Advocate Beatrice Creer. If I may pause very briefly, Advocate Beatrice Creer is a co-author in several articles. She's done phenomenal support in the USAID study, a 2-year study that I did between 2020 and 2022, and also provided assistance, my Lord, in the specific matter in putting together the case annexes related to sentencing. So I'm deeply grateful for Advocate Dr. Beatrice Creer. Telephonic and email conversations with Dr. Monique Emza. She's also a co-author and a fellow member of the counter-trafficking community in South Africa, and has also contributed some insights in terms of gender-based violence and violence against children in South Africa. And the last bullet, email correspondence and telephonic inquiries with the National Freedom Network, the National Human Trafficking Hotline, Missing Children South Africa, Brave to Love, the South African Professional Society on the Abuse of Children, counter-trafficking practitioners, and also representatives of the survivor community. I will then proceed to Section 3, Trafficking in Persons, a global and local overview. On 15 November 2000, the United Nations General Assembly adopted the Convention Against Transnational Organized Crime along with 3 protocols that served as additional instruments to supplement the Convention. These protocols covered the issues of trafficking persons, smuggling, and illicit firearms, which were also open for signature. The international community began meeting in 1999 to draft a protocol to prevent, suppress, and punish trafficking in persons, especially women and children. That is the Palermo Protocol, which took into account that there was no universal instrument that addressed all aspects of trafficking in persons. After adoption, the convention and protocols were formally signed in Palermo meeting in December 2000. What became known as the Palermo Protocol came into force on 25 December 2003 and was subsequently ratified by South Africa on 20 February 2004. As a country that ratified the protocol, South Africa is bound to develop laws to protect the victims of trafficking and to prosecute offenders in a manner appropriate to the seriousness of the offense. On any given day in 2021, an estimated 50 million people were living in modern-day slavery, including 28 million in forced labor and 22 million in forced marriage, an alarming increase of 10 million people since 2016. I will just pause very briefly here to say that there is a host of challenges international research where they attempt to enumerate and to quantify the problem. In this specific report, I have personal concerns about sex trafficking that is frequently considered a subset of forced labor. That's deeply problematic. The only reason I'm quoting this study is because it's the most recently cited estimate, a global report denoting approximately 50 million people. But there's a lot of ideological and philosophical differences in terms of how those types of trafficking are categorized. I just want to make sure to put that as a note. Modern slavery, I'll continue. Modern slavery includes forced labor, debt, bondage, forced and servile marriages, sexual exploitation, human trafficking, slavery-like practices, and the sale and exploitation of children. The terms modern slavery and trafficking in persons are often used interchangeably, leading to confusion about their meanings and scope. Just another pause. Trafficking in persons is considered a subset or a category of modern slavery, but it's safe to assume that we are essentially talking about the same issues here. So for the purpose of this record, I will use the term trafficking in persons, and that correctly aligns with South African legislation. I will continue. According to the Global Slavery Index, I'll use modern slavery is an umbrella term and includes trafficking persons and encompasses various forms of exploitation where a person is unable to refuse or leave due to threats, violence, coercion, deception, or abuse of power. The latest global report on trafficking in persons highlights several special points of interest. This is a 2024 report, and trends and challenges in addressing trafficking in persons globally. So the recent report highlights the 7 categories of special issues that has been noted, and these include that the number of victims of trafficking detected globally is on the rise again after falling back during the COVID pandemic. Secondly, child victims are increasingly detected globally with distinct patterns emerging for boys and girls. Thirdly, trafficking for forced labor is on the rise, but the criminal justice response is lagging behind. The fourth bullet, women and girls continue to make up the majority of victims detected worldwide. The fifth, most trafficking in persons is perpetrated by organized crime groups operating in business or governance types of structures. 6, victims are trafficked globally through an increasing number of international routes, with African victims trafficked to the highest number of destinations. And then the last bullet, displacement, insecurity, and climate change are exacerbating the vulnerability of Africans to being trafficked. The report calls for the need to adapt, and as trafficking persons shift, justice systems need to broaden their focus and be better equipped to address different forms of trafficking, including trafficking for forced labor and across national borders, and to target larger, more structured criminal networks and those at the top of their hierarchies. The report also underscores that child protection and assistance must be fully integrated into all trafficking frameworks. I think that's, just to pause here, very relevant to the South African situation as well. And then to continue reading, the report also calls for priority that must be given to protecting the safety and dignity of victims and people at risk. From the outset of South Africa's ratification of the Collaborative Protocol in 2004, the country has been identified as a source, transit and destination country for men, women and children subjected to forced labor and sex trafficking. As a hidden, subversive and underhanded phenomenon, the crime does not lend itself to accurate quantification. Trafficking continues to be subsumed under cases such as kidnapping, abduction, domestic violence, assault, labor and civil disputes, to name but a few. Ideological debates around, and I'm using I'm quoting here, sex work, unquote, and prostitution law in South Africa further compounds endeavors to quantify human trafficking. I will pause here briefly. It's my opinion that this has arguably been one of the greatest inhibitors that has make legal the rights of men to purchase sexual access to women and children, a very vocal debate which is ongoing, and again, I think it's really diluted our understanding of human trafficking over an extended period of time. I'll continue reading. Studies attempting to quantify the phenomenon of trafficking in persons in South Africa have also been critiqued for truncating the scope of the definition of trafficking and even excluding cases involving the use of force. These South African studies were criticized for incorrectly coding cases as not being trafficking and thus undercounting the prevalence of trafficking for the purpose of sexual exploitation. The collection of reliable data in South Africa is clearly problematic, whilst an urgent need exists for a database that reflects national level and aggregated data. Trafficking in persons in South Africa has also been referred to as an elusive statistical nightmare and a situation that may in fact be far more chronic than anticipated. Several South African studies dating back to the 1990s provide real-world insights into the embedded realities of trafficking in persons in South Africa. In one of the earliest studies in 1996, researchers documented the reality of girls as young as 8 years old being exploited by brothel owners, whilst others aged 11 and 12 were held and exploited in dilapidated apartment blocks. Overwhelmingly slanting towards sex trafficking and sexual exploitation in South Africa's sex trade, their findings lend support to the conclusion reached by Professor Philip Frankel that it would be a surprise if South Africa did not have a trafficking problem. And, he was the author of the seminal book, Long Walk to Nowhere. Okay. The study entitled Research into the Nature and Scope of Trafficking in Persons in South Africa, Prevalence Insights from the Criminal Justice System and Relevant Reporting Mechanisms was released in January 2023 and provided a comprehensive examination of trafficking in persons in South Africa. That study, if I may just pause, was a subset of a larger national study. And I was the author of a specific one, and why I think it's very relevant, my lord, is for the first time it really tapped into all the different buckets of knowledge and insights and statistics. So I'll just go through some of those. This report provided a comprehensive examination of trafficking persons in South Africa, drawing on both qualitative and quantitative analyses of ongoing and successful prosecutions, statistics from SABC, statistics and qualitative insights from NGOs, and a quantitative analysis of media reports. The empirical foundation of the research included data from several key sources, reports from 3 national trafficking persons NGOs involved in provincial and national trafficking persons task teams, as well as one national NGO focused on missing persons. It also included available statistics from SABC covering the period between 2007 and 2021. It also included ongoing trafficking prosecutions in South African courts during 2021, and also trafficking in persons cases successfully prosecuted in South African courts between 2007 and 2022. Together, this mosaic of evidence highlights consistent and coherent themes identified in prior trafficking research, ranging from reports and academic studies to survivor autobiographies and evidence-based media reports. I will just very briefly, if I may pause, just mention what the main themes in that study was. The first one was that the fact that the Act, as Dr. Pietri Kruger found, is really a sharp prosecution tool. So we've got a brilliant Act. The challenge is now is to fully implement it. The second finding was really that there is a scope, a spectrum of perpetrators, from individual linear trafficking perpetrators to vast networks of perpetrators, organized criminal groups. The third finding, which is very relevant to the issue of missing persons in South Africa as well, is entitled The Great Undercount. And there is an enormous undercount of trafficking cases in South Africa. The fourth one was really a look at the sex trade and just this vortex of violence in the sex trade and the role of sex buyers, those who purchase sexual access to women and children, doing so with no compulsion, and people selling women and children equally with no compulsion. And the fifth finding there, my lord, was just really the issue of corruption, indifference, and official complicity in trafficking crimes. I will continue reading. A significant dimension of the studies, I'll just go to this paragraph about statistics. Statistics made available by the South African police services were revelatory. Between 16 December 2007 and 8 August 2015, at least 250 cases of trafficking in persons were reported in South Africa under interim legislation. Following the implementation of the Packet Act on 9 August 2015, the number of trafficking cases reported to SABC rose significantly, totaling 10,820 cases by 17 January 2022. Of these cases, 7,140 of these involved adult victims, 1,463 involved child victims, and in 2,217 cases, the victims' ages were not reported, and that intuitively, implicitly, is really problematic, that the ages of victims are not reported. During the same period, the National Directorate for Priority Crime Investigations, Nodal Point, received 91 trafficking in persons reports from organized crime units within the walls of the DPCI. These cases identified 630 victims, comprising 522 adults, 102 children, and 6 individuals whose ages were not documented. Given the 630 victims identified in only 91 cases investigated by the Hawks, the total number of victims within the 11,000 cluster cases reported to SABC is likely to be substantial. Additionally, between 2018 and 2021, SABC reported 781 South African children as victims of child trafficking. This figure was confirmed by the Minister of Police, Becky Cele, in response to a parliamentary question. My lord, this is also another challenge we have, is this disconnected pieces of buckets of numbers. A lot of this data is really managed in Excel spreadsheets and often do not speak to the different databases. And I think it was raised during the judgment in this case how difficult it is to get access to data in trafficking persons matter. The same applies to reported cases and to missing children as well. I'll continue reading here. These statistics highlight the significant scale of trafficking in persons in South Africa and the critical need for continuing efforts to address and combat this issue. The National Human Trafficking Hotline has also provided crucial data for both 2023 and 2024, illustrating key trends and changes in human trafficking cases. In 2023, the National Human Trafficking Hotline received a total of 3,613 contacts, of which 79% were related especially to trafficking persons. Sex trafficking emerged as the common form of exploitation, accounting to 52% of cases, which marked a 24% increase compared to 2022. Reports indicated that 131 potential victims of trafficking were identified, with minors comprising 22 or basically 23% of cases, a significant rise from the 12% reported in 2022. Additionally, 55% of all contacts targets, up from 22% in 2022, and 48% of trafficking victims were lured through false job opportunities. Overall, the National Human Trafficking Hotline identified and or assisted 42 victims of trafficking during the year. In 2024, the hotline recorded a total of 3,100 contacts, with 55% specifically related to trafficking in persons. The hotline identified and or assisted 55 victims of trafficking, of whom 27 entered the aftercare program. The majority of victims reported during this period were female, that's about 95%, and South African nationals. Contacts from the general public accounted for 45% of total reports, while 78 cases were referred to law enforcement. The top 3 cities for reported trafficking cases were Cape Town, Johannesburg, and Durban. Recruitment through false job opportunities continued to rise, accounting for 56% of trafficking victims identified. Notably, there was a 200% increase in victims identified as being involved in scamming centers. The data reveals critical patterns in the trafficking across South Africa and highlights the importance of victim identification, public awareness, and law enforcement collaboration to combat this growing issue. The annual United States Trafficking Persons Report is considered the most comprehensive global report on the government's efforts to combat severe forms of human trafficking, and this continues to be a go-to tool for many in South Africa, government, and this is just as an aside, my lord. As a source of information, I think the robust methodology, I'll just quickly read this, really contributes to why it provides this consistent and coherent picture of South Africa. So that methodology for the US TIP report includes in-depth conversations and interviews with the entire spectrum of practitioners involved in counter-trafficking work in South Africa. This includes government and civil society, also includes the monitoring and the validation of media reports and the transmission of a standardized questionnaire for completion. Data collected from questionnaires is synthesized, written up, checked and validated through multiple iterations by stakeholders that include multiple officials at the US Embassy in Pretoria and multiple officials in Washington, D.C. South Africa has been featured and rated in the US TIP report since 2001 and has consistently been referred to as a source, transit and destination country for the trafficking of men, women and children exploited for commercial sex and forced labor. Troublingly, South Africa has featured on the Tier 2 watch list of the US TIP report for 5 of the past 10 years. Several consistent response challenges and problematic experiences by trafficking victims, practitioners, and service providers are highlighted in the annual reports. Corruption, official complicity in trafficking crimes, and significant shortfalls in victim identification are among the several factors that inhibit prevalent insights and accurate crime statistics. The numerous and complex interactions between different individuals involved in trafficking process, combined with the dynamic interplay of circumstances, threats, space and time, suggest that traffickers approach control methods as a dynamic, flexible toolkit, selecting tactics as they deem fit. Victims' compliance to traffickers' operations is a central and pervasive theme in trafficking, with various control methods serving as the mechanism through which compliance is achieved and sustained. While an increasing body of research has examined these methods, much remains to be uncovered as traffickers continuously devise new and more covert strategies to evade detection and enforcement efforts. I will just briefly pause here, my lord, and just highlight that research effectively moves and are published at the speed of molasses. And while trafficking as a very material issue happens at the speed of light. So there's no way that research are ever able to keep up with the dynamic field of human trafficking. I just think that's just an important point
Trafficking in persons is deeply embedded in daily life, fueled by societal demand for cheap and exploitative services, and is exacerbated by South Africa's interconnected sex and drug trade. Structural inequalities and abundance of vulnerable populations at risk of exploitation and widespread social indifference to the suffering create conditions where trafficking in persons thrives with little resistance. And may I just add the unity in many ways as well. Many trafficking persons-related criminal operations are fluid, adaptable, and highly sophisticated. These crimes rarely exist in isolation and are often accompanied by other offences such as fraud, drug trafficking, money laundering, and corruption. Additionally, activities like firearms dealing, stolen goods, retail crime, and cybercrime are frequently interconnected within the broader criminal landscape. I'll just pause here and say this is only a small fraction of the things we've seen in South Africa. I have personally reported the issue of criminal networks coming into South Africa, where there is clear evidence of terror-related funding as well, linked with networks such as Al-Shabaab. So those are also just critical pieces which I think is important to highlight as well. Trafficking, the resulting environment fosters multi-layered systems of control and domination over victims, perpetuated by fear, confusion, and anxiety. We've also highlighted the challenges faced by the criminal justice system in effectively combating trafficking in persons. And I'm citing an article we've authored here. It's at the scoreboard in the ongoing battle of wits between the criminal justice system and the human trafficking system that it seeks to combat is convincingly in favor of well-organized and agile human trafficking networks. And my Lord, I think it's also just to pause here and to celebrate, really celebrate every successful prosecution we have in South Africa. There are phenomenal police investigators, phenomenal social workers, and in this case, prosecutors as well, really putting so much on the line to get these cases through the court. These are not difficult, not easy cases to prosecute, so I think it's just important to mention that as well. Despite these difficulties associated with investigating and prosecuting TIP, it is essential to emphasize that every successful prosecution represents a significant step forward. Trafficking in persons remain one of the most complex crimes to address, but persistence in dismantling these networks is critical to ensure justice for victims and holding perpetrators accountable. Okay, I'm going to go into section 4, if I could continue with that. Violence against children as a pathway to human trafficking. Children account for approximately 35% of South Africa's population and constitute a highly vulnerable subpopulation disproportionately affected by poverty, gender-based violence, and structural inequality. In South Africa, children are exposed to multiple intersecting threats to their basic rights and well-being, including poor living conditions, inadequate policing, urban migration, and the absence of parental care. Present at the core of many South African homes is the tough issue of child trauma and gender-based violence. Is a tough issue of how child trauma and gender-based violence intersperse. It is difficult enough for children who see or experience this violence to deal with it, and it has a devastating impact on the emotional and mental well-being and almost every part of growing up healthy. Despite a progressive child protection legislative framework, children continue to face a violent siege in South Africa, really, and renders them both invisible and exploitable due to lack of capacity, budgetary constraints, institutional weaknesses, and policy implementation failures. Violence against children is not only a violation of children's rights, but also a significant structural driver of trafficking in persons, particularly familial trafficking that requires an interrogation of the scale, nature, and the societal dynamics of violence against children in South Africa. Okay, point number 5, conceptualization of violence against children. Article 19 of the Convention on the Rights of the Child of 1989 defines violence against children as all forms of physical or mental violence, injury or abuse, neglect or negligent treatment, maltreatment or exploitation, including sexual abuse, while in the care of parents, legal guardians, or any other person who has care of the child. In South Africa, this violence manifests in both overt and subtle ways, from sexual assault and corporal punishment to emotional cruelty, abandonment, and chronic neglect. Researchers note that violence frequently occurs across all the spaces that children inhabit, whether in the home, school, community, or increasingly also in cyberspace or virtually. Child abuse and neglect remain endemic. There is a saturation of violence in the everyday lives of many South African children who regularly experience multiple forms of violence, which also often intersect. This is also acknowledged in the South African National Plan of Action for Children, which states inequality, social exclusion, and violence against children continue to be extremely high. Large numbers of vulnerable children remain trapped in environments where they are subjected to developmental risks, including poverty and high levels of violence, abuse, neglect, and exploitation. Vulnerable children remain trapped in an inequitable cycle of exclusion and poor development, which drives both poverty and inequality. This is further intensified by grave limitations in the overarching child care and protection systems. Moreover, families and homes, despite their protective possibilities, often remain the most vulnerable place for young children. Thus, it is important to recognize that childhood trauma often begins in the home, where structural and social vulnerabilities intersect to produce lasting harm and are exacerbated by poverty, gender inequality, caregiver, substance abuse, and unresolved intergenerational violence. The paradox of the family as both a safe haven and a site of harm is fundamental to understanding violence against children. Section 6, the scope of violence against children. Violence against children in South Africa is endemic and multifaceted. The prevalence of violence against children in South Africa is unsettling and points to wider societal issues. South Africa's child homicide rate is twice the global average, and 51 cases of child sexual abuse are reported daily. I'm just citing some studies there, the Optimus study 2016. There's also found that 1 in 5 children experienced sexual abuse, 1 in 3 experienced physical abuse, 1 in 6 reported experiencing emotional abuse, 1 in 8 reported being neglected, and 1 in 6 reported witnessing violence in their homes or community. In terms of physical and sexual abuse, South African children experience more violence compared to the global average. However, these figures represent an underestimation of the pervasiveness of violence against children. Some smaller scale studies, like one conducted in Soweto, has found that as many as 99% of children had witnessed either direct or indirect violence in their lifetime. Recent data reveals that 45% of South African households with children reported some form of violence against children between 2021 and 2022. A significant proportion of violence against children in South Africa remains hidden from official statistics, as cases often go unreported and undocumented. It's also further argued that the police may be failing to fulfill their statutory duty to report cases to the Department of Social Development under the Children's Act, raising concerns whether children are receiving timely and appropriate care. Authors have further noted and contend that the growing levels of child exposure to violence can be linked to systemic misalignment and poor coordination between child protection entities. This has also been attributed in part, at least, to a pervasive culture of silence embedded within communities and institutions. This silence is shaped by multiple interrelated factors, social exclusion, distrust in law enforcement and judicial processes, and the normalization of violence in some domestic and social settings. Victims, particularly children, may be discouraged from speaking out due to fear of not being believed, retribution by perpetrators, often within their own households, or the absence of accessible support structures. This culture not only conceals the true scale of abuse, but also undermines efforts at prevention, justice, and rehabilitation. Okay. Section 7. Violence against children as a threat, magnifier, or enabler of trafficking in persons. Trafficking in persons flourishes in contexts marked by institutional failures, entrenched poverty, and social exclusion. Children are particularly at risk when they are rendered invisible, neglected by social services, unheard by legal systems, and unsupported by caregivers or communities. Violence against children acts as a powerful threat magnifier for trafficking in persons, intensifying children's vulnerability by eroding their protective environments and personal resilience. Exposure to abuse, neglect, and maltreatment increases the likelihood that children will disengage from support systems, experience social isolation, and develop trauma-related vulnerabilities. In this case, violence against children does not merely coexist with trafficking in person, it actively facilitates it. And I just want to pause here, my Lord, and I think another thing we could learn from this over the last, let's say, 25 years, is that none of these things ever exists in its own private universe. There's no way that we can put gender-based violence in a bucket, or child protection in a bucket, or trafficking in persons in a bucket. There are obviously respective laws addressing each one of these phenomena, but it's so important that a holistic approach to this is important, because that's also where the data crevices falls through the gaps. So many of the gender-based violence and domestic violence issues as key trafficking persons indicators in them, and often data that's collected in one environment doesn't translate or inform other environments. So often we have these echo chambers that exist, and it really is very counterproductive to really understanding the whole picture of trafficking in persons, including missing children in South Africa. I'll continue. The structural breakdown of child protection safeguards creates a fertile environment for exploitation to take root and persist. It's been noted that children who have experienced child abuse, familial dysfunction, relational loss, and removal into foster care represent a disproportionate percentage of trafficking children. In addition, early trauma can compromise a child's ability to assess danger and make decisions in their own best interest. Early adversity may contribute to developmental problems, educational and relational difficulties, decreased danger awareness, and increased vulnerability to manipulation. This is exponentially compounded in the case of familial trafficking, where the very individuals entrusted with a child's care become the facilitators and or perpetrators of exploitation. Such betrayal not only strips the child of their primary source of protection, but also complicates detection and intervention. Familial trafficking exploits the trust inherent in caregiving relations. It erodes the child's sense of safety and identity, and it often silences them through fear, dependence, or coercion. It represents one of the most insidious forms of trafficking. It is estimated that 41% of child trafficking cases are facilitated by family members and or caregivers. That is an IOM statistic, or an IOM number, the International Organization of Migration. Notably, governments and anti-trafficking stakeholders overlook familial trafficking, which is when a family member or guardian is the victim's trafficker, or the one who sells the child to a third-party trafficker. The facade of the, quote, the family, unquote, not only shields violence against children and the exploitation from public scrutiny, but also makes it more difficult for victims to disclose primary caregivers of, and therefore are some of the main perpetrators of early home violence against children. Women are disproportionately represented in this form of trafficking. I'll move over to Section 8, State Responsibility and Institutional Weakness. Violence against children constitute a direct violation of their fundamental human rights as enshrined in Section 28 of South Africa's Constitution, which guarantees every child the right to be protected from maltreatment, neglect, abuse and degradation. Such violence also breaches South Africa's obligations under a range of regional and international human rights instruments, including the UN Convention on the Rights of the Child, the optional protocols thereto, and the African Charter on the Rights and Welfare of the Child. These instruments collectively affirm the state's duty to ensure children's safety, dignity, and well-being. However, despite the gravity of violence against children and trafficking persons, South Africa's institutional response has been characterized by fragmentation, underreporting, underinvestment, capacity constraints, and a lack of accountability. Instead, they remain largely aspirational due to lack of effective measures to enforce the rights of children to life, survival, and development. It's also been noted that political and financial investments to prevent violence against children remain low, despite the cost of inaction in 2015 amounting to nearly 5% of the country's gross domestic product. A particular risk for child maltreatment is also inherent in poorly functioning police service and criminal justice system, and combined with an overwhelmed social development service, this means that cases of child maltreatment end up underreported, delayed, or reprioritized over cases deemed more serious in nature. Other cases go uninvestigated or abruptly dismissed by the criminal justice process. In most cases, or most instances, maltreatment is considered a child welfare issue and redirected to social development services. Where violence occurs with impunity or is met with inadequate institutional response, it not only undermines legal protections, but also nullifies the broader rights framework meant to uphold the best interests of the child. The state thereby becomes indirectly complicit in the trafficking of children. Okay, my Lord, I'm going to go over to Section 9 of the report, Missing Children in South Africa. While not all missing person cases are connected to trafficking persons, many trafficking persons incidents are typically individuals who are reported or perceived as missing. This connection, however, remains largely unexplored. Children and adults go missing for a variety of reasons, often linked to challenging or traumatic circumstances. Some may run away from home to escape issues such as domestic violence or sexual violence, while others, particularly those with mental health challenges, may become lost. Individuals can also fall victim to crimes, including gender-based violence and kidnappings. And obviously kidnappings has various subsets, parental abductions or kidnapping for ransom, etc. And it obviously also includes trafficking persons. In some cases, missing persons are later discovered in mortuaries as unidentified individuals, while others may disappear due to suicide. In a comprehensive four-part essay on missing children in South Africa, and I just want to mention this amazing child protection advocate, Robin Wilson Foster. She did this incredible four-part series on a journalistic piece, really, on missing children in South Africa, and it was quite a read. So I'll just quickly go into some of her quotes. So this four-part series is really a meticulous research exploration of the sociological challenges that engulf South Africa's missing children, and it's laid out by her. She highlights the voices specific attention to South Africa's so-called ghost children, the countless unreported missing children. And I'm going to quote Robin here, where she raises an important question, and I'm quoting, my Lord. While the government claims that there is no missing children problem in South Africa, statistics as they are can only be valid if all missing children cases are reported. But in a country where poverty, fear, mistrust of the police, cultural practices, and even parent complicity result in cases going undisclosed, children are significantly underreported. It then raises the question, how do you find children if no one knows they are missing? Unquote. I just want to pause very briefly. I recently saw a quote on a news brief where somebody referred to these kind of children. I think, the ghost children is an apt reference. And the commentator mentioned that these are the type of children whose births are not celebrated and whose deaths are not mourned. And I thought that was a poignant, visceral statement and really an indictment on humanity in terms of the surmise of some of these kids. I'll continue reading. One of several examples of South Africa's ghost children is highlighted in a case that the author personally managed. My Lord, I'm referring to myself here. It was a case received through the National Freedom Network, and I would often receive these cases. I earlier cited in the region of about 900 plus human trafficking cases that I received, managed, or investigated after leaving the police. So this is kind of a part-time ad hoc function that I kind of held and that I did. And often you would receive these calls from people where they were not able to report cases to the police. And then we, as a National Freedom Network, we would jump in and we would pretty much complete an entire case report or case document and would then hand that over to the police. But I remember this one instance, this was an elderly lady from Ackridgeville in Pretoria, and she reported a case concerning a 20-year-old stepdaughter went missing after traveling to Johannesburg for a job opportunity. After receiving no assistance from SABC, she made contact with me and I obtained a statement and the case was officially registered. The stepmother explained that her stepdaughter, and I'm using a pseudonym, Tembi, left home on 6 December 2019 to accept an employment offer. When Tembi failed to make contact by 8 December 2019, the stepmother attempted to reach her repeatedly, but Tembi's phone was switched off. She eventually called the stepmother, probably about 6 weeks later, on 20 January 2020. During this brief emotional call, Tembi whispered and cried hysterically, stating, and I'm quoting from the statement, "The woman who offered me a job sold me to Nigerians." She further revealed that she was being held in a residential brothel in Johannesburg, where she and other girls, some as young as 12 years, were being exploited. She added, "They are selling us to different people," and she noted that her captors were armed. Tragically, Tembi's location, as well as the fate of the other potential child trafficking victims she mentioned, remains unknown. And my Lord, I'll just briefly pause here. I did make available the USAID study that I authored, and within that study there's about 3 diagrams that speaks to these invisible victims of trafficking, where there is consistent corroborative evidence that there are countless people in the building, in a room, where this comes out from victim testimony. And then when you enumerate these individuals, sometimes their names are known, or sometimes a mere reference to there was 5 or 6 others in the room. When you start enumerating these numbers, the statistics easily goes up by 10, 20, times 20. Again, just highlighting and underscoring cases of trafficking and reported cases of missing children in South Africa. These cases are intricately intertwined with the layers of violence that have become embedded in South African society in the democratic era. I will now go to point number 10, my Lord, and this is the missing person statistics in South Africa for the period 2000 to 2020, over a 20-year period. I just want to make it very clear, again, my Lord, it was mentioned in the judgment, it's almost impossible to find numbers, access information, this should be readily available, not just to government agencies who's working on this issue, but also for research and maybe even the public. So I was really very fortunate, my Lord, to get access to these numbers because they are not publicly available. So I'll go into these numbers and they are quite staggering once you consider that this still is only the tip of the iceberg. So I'll just continue reading here. To provide a comprehensive understanding of the missing persons phenomenon in South Africa, this report references two data sets provided by SABC. The first data set reflects information between 2000 and 2015, and the second data set between 2000 and 2020. According to the 2016 data set from SABC, a total of 49,346 adults were reported missing between 1 January 2000 and 31 December 2015. Of these, 25,543 cases were cancelled, indicating the individuals were found, while 23,800 adults remain unaccounted for or still missing by the end of the period. For children under the ages of 18, 14,252 were reported missing in the same time frame over this 15-year period, with 10,295 cases cancelled where the children were found. This left a number of 3,957 children missing or unaccounted for over that 15-year period. These figures collectively indicated that by the end of 2015, a total of 27,760 individuals, and that includes adults and children, remain missing or unaccounted for in South Africa. Now going to the 2020 data set from SABC, provided updated statistics for the period over a 20-year period, 2000 to 2020. Over these 2 decades, and I'll really just to pause my notes, how these numbers work, there's this iterative process of clearing cases, so the numbers are constantly, almost like in a state of flux, where they recalibrate the numbering. So the 2015 numbers might not perfectly fit to the 2020 numbers for a variety of reasons where cases are kind of distilled. So over these 2 decades, a total of 94,252 individuals were reported as missing, comprising 78,100 adults and 16,000 children. Of these cases, 62,700 were cancelled or resolved, leaving 31,545 active cases of individuals still missing or unaccounted for. Notably, this reflects an increase of 3,785 unresolved cases since 2015. This time that 5-year period, that was an additional 3,785 cases, highlighting a concerning upward trend in unresolved missing persons cases. The numbers presented in these data sets, while significant, reflect only a small fraction of the broader missing persons crisis in South Africa. Significant underreporting, limited investigative resources, systemic issues with law enforcement, corruption, complicity, and general indifference have all constrained the accuracy and scope of these statistics. I'll just pause here, my Lord. I've just over the last 23 years, I probably have a library of case studies how how of each one of these shortfalls, of how these numbers fall through the cracks. Actual cases, one example where, official complicity, where, corruption, where statements are altered, or there is a connection at a local police station where a trafficker asked or paid a police official to write a false statement to say, well, the child is, it's now been, well, the information has been found in the Durban area, while the child is not in the Durban area. It's just helping a syndicate, keep control over victims of trafficking. It's just one example, but there are just countless examples of why these numbers are skewed. The surge in unresolved cases reported between 2015 and 2020 highlights the burden. Increased resources and a greater public awareness to tackle this critical issue effectively. Compounding this crisis is the widespread sentiment among families and communities that reporting a missing person is often an exercise in futility. Many individuals opt to wait for a loved one's return or to take matters in their own hands rather than endure the trauma of being turned away by law enforcement. People frequently report being told to return after 24 hours, 48 or 72 hours, only to face further barriers and excuses for why a case cannot be opened. This reality is especially alarming for those in poor and vulnerable communities who are disproportionately affected by this systemic failure. Having personally faced these challenges as a former Hawks investigator, the author, or myself, has experienced immense difficulty of reporting a missing person, even during my work with the National Freedom Network. On more than one occasion, I was personally threatened with arrest for being too persistent in trying to ensure that a case was taken seriously. If such obstacles can be insurmountable, for someone like me with professional experience in law enforcement, one can only imagine the frustration and the hopelessness faced by ordinary citizens. Addressing this issue requires a fundamental shift in both policy and the approach of law enforcement to restore trust, ensure accountability, and provide meaningful support to those seeking help. I just want to pause very briefly and just re-emphasize that the reason why we have this matter today is because there's just brilliant people out there, law enforcement officials, prosecutors, social workers. So this is by no means a broad brush being stroked here. So I just wanted to make sure that I state that for the record, my Lord. I'm going to section 11, trafficking in South Africa, voices from the field. This summary presents to the court the essence of insights derived from conversations and email correspondence with several counter-trafficking actors in South Africa, dedicated individuals and organizations actively engaged in the fight against trafficking. These voices from the field provide a critical ground-level perspective on the nature, scope, and challenges of this crime within the country. So my engagement with these actors was just really an initiative to ensure, my Lord, that my own research experience and ongoing observations of the South African landscape align with the realities faced by those currently combating trafficking in South Africa. What follows is a distillation of their collective contributions intended to inform the court of the complexities of trafficking and the systemic issues that perpetuate it. So trafficking in South Africa is not just a recent development, it's a crime deeply embedded in the nation's historical and ongoing structural inequalities preceding the legacy of apartheid. And I've included a footnote here that references the case of Saartjie Baartman, well documented, where a court found that it's doubtless that she had no desire to be exhibited. It's just one of the most tragic cases in our history, but just pointing to the fact that subjugation and slavery is not an anomaly, it's not a recent development, it has been there for a very long time. I'll continue reading. These conditions, characterized by widespread poverty, unemployment, educational deficits, really create a fertile ground for traffickers to exploit vulnerable populations. South Africa functions as a source transit and destination country for trafficking, with victims subjected to a range of exploitative practices. Practitioners emphasize that trafficking intersects with numerous criminal enterprises, including drug trafficking, prostitution, child exploitation, and illicit mining, forming a multifaceted and elusive network that resists straightforward classification or resolution. Sex trafficking, while a focal point in public and policy attention, represents only one dimension of this pervasive issue. Labor trafficking, by contrast, is increasingly identified as a widespread yet unexamined problem. It occurs across industries such as agriculture, illicit mining, and domestic servitude, often facilitated by exploitative labor brokers and recruiters. Despite its scale, labor trafficking is frequently eclipsed by the emphasis on sex trafficking, resulting in countless victims remaining undetected and unprotected. Additional forms of trafficking, such as the harvesting of body parts or the use of individuals for criminal acts like drug dealing, also persist, though they attract minimal scrutiny or resources. The reach of trafficking in persons is amplified by organized crime. International syndicates originating from regions including Africa, Asia, and Eastern Europe exploit South Africa's porous borders and advanced transportation infrastructure to operate with apparent impunity. Children are especially at risk, ensnared in practices such as forced marriages, child sex tourism, and the so-called blessed phenomenon, where material gains are traded for sexual favors, obscuring the boundary between perversion and consent. The advent of technology, particularly social media and online platforms, has further expanded trafficking scope, enabling recruiters to target victims with unprecedented efficiency. Emerging factors such as when individuals are deceived into traveling abroad or forced into online scams underscores the crime's adaptability. Yet its clandestine nature and the absence of centralized data continues to hinder a full understanding of its magnitude. The South African government has taken steps to address trafficking, notably by ratifying international protocols and enacting legislation lauded by practitioners as progressive and prosecutorial in its intent. This legal framework seeks to prevent trafficking, protect victims, and prosecute perpetrators. However, those in the field consistently report that these measures are undermined by profound deficiencies in implementation and enforcement. Law enforcement and judicial personnel frequently lack the training and resources to identify victims or pursue traffickers effectively, leading to misidentification or dismissal of cases, inadequate monitoring and investigation, particularly in labor-intensive sectors like agriculture, mining, and fishing, exacerbate the problem. High-profile incidents such as mining disasters often fail to acknowledge trafficking victims, revealing a systemic oversight of internal exploitation. Leadership instability in the counter-trafficking movement and frequent turnover among key officials disrupt strategic continuity, rendering government efforts disjointed. Law enforcement agencies grapple with understaffing and the attrition of skilled personnel to private sector, while practices such as granting bail to traffickers weakens attempts to dismantle networks. International collaboration, vital for confronting transnational syndicates, remain underdeveloped, with agreements with neighboring states yet to be fully operationalized. Most critically, the lack of effective victim identification mechanisms and support systems leave survivors without adequate protection. Shelters and related infrastructures are reported to be in a compromising state, plagued by insufficient oversight and funding, denying victims access to safe havens, legal assistance, or mental health care. These shortcomings prevents the government from accurately assessing the problem or crafting precise interventions, perpetuating a cycle of victim invisibility and trafficking impunity. society and NGOs really serve as a vital counterweight to governmental shortcomings. Frontline workers, including social workers, advocates, and volunteers, describe these entities as indispensable in supporting victims, raising public awareness, and pushing for policy reform. Their qualitative insights illuminate trafficking nuances, identifying trends such as the prevalence of minor victims, the rise of cybercrime, trafficking, and the hidden scale of labor exploitation. NGOs often undertake high-risk activities, which includes victim rescue, rehabilitation programs, and community outreach, often partnering with law enforcement. Their efforts really uncovers alarming patterns such as familial exploitation driven by poverty or coercion, which complicates victim identification and protection. Yet their effectiveness is curtailed by scarce resources and poor coordination with state agencies. Dependent on limited donation, these organizations struggle to expand their reach or ensure sustainability despite their critical contribution. Just to pause very briefly, I'm just reminded by an organization like Missing Children South Africa, just my goodness, being on the front end of all things missing children for, I think it's almost close to 2 decades now, really at the tip of the spear of this. So yeah, just sort of just quickly illuminate that. I'll continue reading. Systemic failures within the criminal justice system or persistent concern raised by practitioners. Trafficking networks, agile and well-resourced, consistently outmaneuver an underfunded and overstretched system. Law enforcement's constrained capacity and the shortage of trained personnel allow traffickers to exploit weaknesses with little consequence. Corruption within government and law enforcement has been widely reported and further entrenches the crime with reports of officials accepting bribes, issuing fraudulent documents, or even participating directly in trafficking operations. This complicity facilitates cross-border victim movement and shields syndicates from prosecution, eroding institutional integrity and public trust. The combination of systemic deficiencies and corruption sustains a low-risk, high-reward environment for traffickers, fueled by greed, porous borders, and fragmented enforcement. Trafficking persons in South Africa, as articulated by those combating it, is a deeply entrenched and dynamic crime, necessitating a robust unified response. The government's legal framework, though promising, is weakened by poor execution, resource deficits, and neglect of victim needs. Civil society NGOs offer essential support, yet their potential is limited by inadequate state backing. Systemic failures and corruption perpetuate an environment where traffickers thrive. Practitioners advocate for a comprehensive strategy. This includes bolstering of law enforcement training and funding, enhancing victim identification and support, and fostering government and NGO collaboration. They stress the need to combat corruption and address the enabling factors including poverty, inequality, and lack of education, while adapting to new threats. Improved data collection and public awareness are also critical to dismantling the structures sustaining this crime. These insights compel the court to recognize the urgency of a coordinated, survivor-focused approach to eradicate trafficking in persons in South Africa. My Lord, if I may just ask, can I pause here? And I just wanted to check that I should continue.
My Lord, I'm glad that the doctor has stopped there. I also wanted to ask whether we should perhaps just take a short body break. May I suggest, I know that we are on page 17, so we're almost to the end of the report. I don't know if my court thinks that this is perhaps
how much time does the witness still have for us? Remember, he has another commitment later, yes, and we still need to get cross-examination as well.
Yes.
Let's take 7 minutes past. I will pause the recording first. I'll keep the line live
Yes.
so that we don't lose it.
Yes.
Maybe we should take, if it suits the witness on that side, take a longer break for be 23 minutes until past. At the same time, you can use the opportunity to find out what happened to the absconder.
Well, my Lord.
And then we start at past and then try and run through until the end of the witness's
Yes.
evidence. Will that suit everyone else? I'm looking at the defense table. Till past, and don't tell me it's less minutes, Mr. Harmson. We'll take the adjournment till 11, and then we'll return. Thank you. Court will adjourn. Dr. Van der Walt, you're still under oath?
Noted, my Lord.
Thank you, my lord. Dr. Van der Walt, I don't know if this is on. Yes. We start your evidence on page 17. We are about to start with number 12, sentencing. You may proceed from there on, please.
Thank you. Right, my Lord. Okay, number 12, sentencing. The evidence before the court presents a substantially aggravated scenario with several important factors to consider. The consideration of these factors within the context of the national attention, and I may all add my international attention that's been garnered in this matter, and the egregious nature of the crime underscores the importance of protecting vulnerable victims and society at large under the Prevention and Combating of Trafficking in Persons Act. So Section 14 of the Backup Act provides aggravating factors that the court must consider, which includes, but is not limited to, the following. I'm just going to go through that list, A to L. Firstly, the significance of the role of the convicted person in the trafficking process. B, previous convictions related to the offence of trafficking in persons or related offences. C, whether the convicted person caused the victim to become addicted to the use of the dependent-producing substance. D, the conditions in which the victim was kept. E, whether the victim was held captive for a period. F, whether the victim suffered abuse and the extent thereof. G, the physical and psychological effects the abuse had on the victim. H, whether the offence formed part of organized crime. I, whether the victim was a child. J, the nature of the relation between the victim and the convicted person. K, the state of the victim's mental health. And L, whether the victim had any physical disability. In considering the case before the court, the relevant aggravating factors from the aforementioned list will be considered and blended with the relevant aggravating factors highlighted as guidelines in the international instruments of the publications that I list there. All three of them are, two of them is UNODC Sources, United Nations on Drugs and Crimes, and then the second one is a handbook for criminal justice practitioners that comes from the Department of Justice in Canada. So the following discussion will consider the available information sources that were made available to the author. I'll just pause here as well, my Lord. The dynamic that Joshlin is still missing obviously plays into the fact that there are a limited number of these factors that I considered. So the first one is the overwhelming majority of trafficking cases involve significant planning and deliberation on the part of the offenders. This case demonstrates clear evidence of planning and premeditation. Accused 3 had devised a plan to sell Joshlin as early as August 2023. This indicates significant forethought and intent, as the accused had ample time to consider and deliberate over the nature of the actions and the consequences for Joshlin. This was not a spontaneous act, but a calculated crime. The evidence also strongly suggests no other alternative but that Joshlin was sold for the purpose of exploitation. This aligns with established patterns of trafficking crimes where victims are treated as commodities with financial earning potential. And I'll just pause here and say that part is very clear in this case. The accused therefore knowingly commodified Joshlin, prioritizing their financial motives over her well-being and safety. There was clearly a common purpose
an agreement among the three accused and Ms. Lombard. The agreement entailed that Joshlin would be sold and that all parties involved maintain silence, therefore obstructing justice and concealing actions. This level of coordination and secrecy points to a shared intent and complicity in this crime. It's clear that all three accused, along with Ms. Lombard, were aware of or should have reasonably known that Joshlin was being sold for exploitation. Their actions reflect a continuous and willful disregard for Joshlin's dignity and safety and illuminate the culpability and malicious intent. It's also very clear that all parties involved stood to gain financially from this transaction. The financial motive underscores the calculated nature of the crime, as the exploitation of Joshlin was not incidental, but rather a means to an end for their personal benefit. When considering the mosaic of evidence, and I would add that the constellation of circumstances in this case, becomes undeniable that the accused engaged in a deliberate, premeditated process. I'll just skip down there. The accused's decisions to refrain from testifying in their own defense further strengthens the need to draw adverse inferences, as their silence in the face of such compelling evidence, the fact that this was not challenged, suggests an unwillingness or inability to refute the allegations against them. Then, in terms of Section 14A of the Packenham Act, the significance of the role of the convicted person in the trafficking process must be considered by the court. In this case, the facts show that accused 3 had been planning to sell Joshlin as early as 2023, demonstrating her central role in the trafficking process. Joshlin was indeed sold for the purpose of exploitation, and all 3 accused, including obviously Apollos and Ferrain, had reached an agreement with Ms. Lombard, as included in that agreement. This agreement included selling Joshlin, remaining silent about their planning, ensuring that no one, including the police, would find out. This shared understanding underscores the common purpose among the accused. If one of them was even remotely perceived to pose a threat to this plan, the configuration would likely have been disrupted, and a very different set of facts and circumstances may have been on the table. All 3 accused and Ms. Lombard were aware, or ought reasonably to have known, that Joshlin was being sold for exploitation. They all stood to financially benefit from this transaction, reinforcing their collective culpability. The roles of the accused were both complementary and coordinated. Kelly Smith, as the mother, played a particularly significant role as the orchestrator of the plan, pointing to significant culpability on her side. Similarly, Apollos and Ferrain also played vital roles in enabling and reinforcing the trafficking process. Collectively, their actions solidified the lies and deceptions, entrapping the victim, unbeknownst to her, in a web of inevitable harm. Section 14J can be considered as a symbiotic consideration to Section 14A. So Section 14J, the nature of the relation between the victim and the convicted person, requires the court to consider how Joshlin's mother deliberately planned to sell her daughter for exploitation. Evidence indicates that there was an agreement between the 3 accused to sell Joshlin, remain silent about their plan, and financially benefit from the transaction. And I think, if I may just pause, I think this is a sobering thought. Just the betrayal by a parent, the very person trusted to protect and nurture their child, is really particularly heinous and significantly, aggravates the court, my lord. This betrayal, coupled with accused 3's role in orchestrating the exploitation for financial gain, emphasizes the severe abuse of trust inherent in the mother-daughter relation. All 3 accused reasonably knew that Joshlin was being sold for exploitation, and the common purpose highlights the calculated exploitation of a vulnerable child by those who should have safeguarded her well-being. Then the crime were committed by motivated by financial material gain. So I know that there's some repetition here, my lord, but I'll just go through some of this. The crimes committed in the Joshua case were clearly motivated by financial and material gain. Tip is widely recognized as a high-income, low-risk offense driven fundamentally by greed and the prospect of financial benefit. This aggravating factor is present in all trafficking cases and must be given significant weight during sentencing. I'm just quoting some international authority here, or literature. Financial gain should not be narrowly interpreted as only monetary, as noted by the UNODC. Payment in kind, such as free accommodation, food, access to vehicles, and gifts all represent a financial material gain for the offender. At its core, tip or trafficking persons involve the subjugation of the victim by accused for their financial material benefit, treating the victim as their commodity in a calculated business decision. In the Joshlin case, the evidence leads to only one set of reasonable conclusions. That is that accused 3 had planned to sell Joshlin as early as August 2023, and Joshlin was indeed sold for the purpose of exploitation. I'll just skip down slightly to just not repeat. Furthermore, the accused know or should have known reasonably that Joshlin was being sold for exploitation, and all 3, along with Ms. Norwood, stood to benefit financially or materially from the transaction. Unlike the one-time financial gain from the transactional sale of an inanimate object, the nature of Joshlin's exploitation, though not fully detailed before the court, plausibly suggests a potential for consistent, predictable, and recurring revenue for her current exploiter, if there is somebody like that. This ongoing exploitation, fueled by greed, represents a grave violation of Joshlin's fundamental human rights, including autonomy, dignity, freedom, and security. In the absence of testimony from the accused persons, this plausibly continuous and deliberate nature of this abuse makes it especially heinous and calls for serious consideration and an aggravating factor in sentencing. Next, the victim in this case, Joshlin, was a child and therefore clearly falls into the category of vulnerability as defined in Section 14I. Vulnerability as a factor plays a critical role in the majority of trafficking cases, and in this case, no exception. Section 4410 also of the Packeter Act emphasizes the significance of social context and the element of vulnerability, both of which were intertwined with the perpetrator's ability to deceive, manipulate, and exploit. In this instance, the abuse of vulnerability under Section 4.1 of the Packeter Act clearly applies. The deliberate targeting of Joshlin as a child, as a victim, demonstrates the exploitation of her inherent vulnerability. This led to a situation where Joshlin had no reasonable alternative but to submit to the exploitation at that moment the transaction took place, fulfilling the definition under the Act. Specifically, her status as a child was exploited, and this aspect underscores the gravity of the offence. Her mother, accused 3, had been planning to sell Joshlin again as early as August 23 and indicates an intentional and calculated effort. All 3 accused were fully aware of Joshlin's acute vulnerability and the nature of the plan underscores their culpability. In the light of the above, the evidence paints a clear picture of deliberate exploitation, coordinated effort by the accused, and a breach of societal and legal obligations to safeguard the most vulnerable among us. I just want to pause here, my Lord. I think the issue of child protection and Child Protection Week, it is constantly on the radio, on the TV. There is no possibility in any universe where this messaging from all sectors of society, the news, the radio, social media, constantly, wave after wave after wave, speaks about the issue of children and their vulnerability, and I think there's no way that this can be ignored. That we live in a society where these things are so systemic, but there is a counterweight. Child protection advocates and media that constantly talks about the vulnerability of children. So there is also an innate knowledge in communities about the importance and the responsibility to care for those most vulnerable among us. So the victim in this case, 6-year-old Joshlin, very likely and plausibly suffered abuse, Section 14F, that came at both a physical and psychological cost, Section 14G. Was exact details of the abuse remain unclear due to unknown whereabouts, it is highly unlikely that Joshlin did not endure at least some form of harm. The mention of the physical traits, such as her eyes and light-colored skin, suggests that she may have been subjected to exploitation. Very likely, though, it would be disingenuous to assume that she was placed in such a situation merely for admiration. Evidence relating to harm and child abuse paints a grim picture, and it is very plausible that Joshlin experienced severe abuse and either physical or psychological harm. You know, I'm just thinking, what thoughts might have crossed her mind as a 6-year-old when she was first recognized that something was profoundly wrong. You know, those are just some of the thoughts that stays with me, and I think with so many people that is following this case. You know, what was some of the thoughts when she realized that this is a fate? In every trafficking case, harm inevitably leaves a lasting impact on the victim. For Joshlin, it is no different. Her case highlights the devastating reality of trafficking in persons where abuse and exploitation leave victims with deep physical and psychological scars. I will now proceed with final analysis into some of my concluding remarks. My Lord, I'll just pause here, and I just want to say I think we are truly at an inflection point, and I hope that this case is it, you know, that really makes us reflect, you know, whether it is in terms of how we manage data in South Africa, you know, how we make available reported court cases. I mean, I do think there's room for entire overhaul in terms of how we do trafficking, counter-trafficking work, how we do gender-based violence, how we do child protection. And I hope, and my prayer is that this is the case, that Joshlin is the matter when we recalibrate. So, and I'll just start reading. About 25 years ago, you know, the landmark international treaty, the Palermo Protocol, was introduced to combat trafficking in person. It really set a global standard for addressing this egregious crime. And South Africa has done well in terms of domesticating legislation, and today we celebrate the Package Act, and today the Package Act is the reason why, you know, we have this successful conviction. But so 10 years ago, South Africa took the significant step, and we now have this law, and it really provides a legal framework to combat the crime. The disappearance of 6-year-old Joshlin really stands as a sober reminder of the work that remains undone. Joshlin's case should serve as an inflection point in South Africa's fight against trafficking in persons. Ultimately, a fight for human dignity, for human flourishing, and against the crippling societal indifference that allows traffickers and predators to operate with impunity. Josh's story is by no means isolated. It symbolizes the thousands of other children who have vanished into the shadows, many of whose disappearing occurrences were never recorded, and the thousands more who will suffer the same fate unless decisive action is taken. The lack of integrated information management system for trafficking in persons and the lack of systemic and transparent processes for preventing, documenting, and addressing missing children in South Africa are truly just unacceptable gaps that perpetuates this crisis. Trafficking is one of the most severe human rights challenges of our time, yet it often fails to receive the attention it urgently demands. While the world grapples with numerous crises, that trafficking person remains a moral wound that we must address collectively and decisively. Each of the 50 million or dare I say, the estimated 50 million TIP victims globally, has been robbed of their freedom, dignity and potential. In South Africa, the issue is far from abstract, far from it. It is a harsh reality, rooted in local vulnerabilities and global inequalities demanding immediate and resolute action. The crime thrives in the shadows, exploiting environments of poverty, inequality and lack of awareness. Vulnerable children and adults, whether in rural areas, urban centres or along the borders, are caught in these networks of exploitation. We cannot ignore the stories of victims like 6-year-old Joshlin, who is still missing. Her case is a stark reminder of the countless other Joshlins out there, names we may never know have been taken and never found. And every child really represents a family shattered, a future stolen, and a society that has failed to protect its most vulnerable. My Lord, if I may just pause here briefly, this, when I started following the Joshlin matter, it vividly and viscerally reminded me of just one of, and I think there's several similarities along the issue of vulnerability and socio-economics, etc., of a case that I've investigated, a missing girl that to this day is missing, and her name is, and I hope still is, Janice Kapora. She went missing on New Year's Day in 2000. She went missing on New Year's Day in 2008, and she went to the. It was a family outing New Year's Day, and Janice from a very poor community in Port Elizabeth, Galvindale, it's poor community in Port Elizabeth, went to the beach, and Janice was missing, and I received the case, and at that time I was still with the Child Protection Unit, and information came that Janice was, that her cousins had a role to play in her disappearance, and eventually there was rumors of Janice being sold to a West African syndicate, and I started to investigate that link, and we truly believed we had solid line of inquiry, and that Janice is being detained or held at the Maitland Hotel in Bloemfontein. We did a big operation, about 300 law enforcement officials. The perpetrators were tracked for quite some time, but we did a raid and Janice was never found, but we managed to find at least 8 other children. One of them was an 11-year-old girl who was trafficked from Alival North to Bloemfontein. And by the time I found her, she was 14 years old. And again, just so many of these cases. But at the end of the day, Janice is still missing. But Janice really opened the door to so many other knowledge and awareness around this issue of human trafficking and missing children. And I think my thoughts and my prayer is like the same happens with Joshlin today, that there is a recalibration of commitment and knowledge and dedication to, the well-being of children in South Africa. And that is a collective issue. It's not just the police or social development, this is a collective issue. But conversely, that perpetrators and those found guilty of these crimes should be held accountable. Guys, I'll just continue here, I'm almost done. The fact that so many of these crimes continue unabated with no compunction from their perpetrators must not and cannot continue. Human trafficking, known as a crime of vast impunity, continues largely unabated in South Africa. The longer such crimes continue unabated, the greater the number of victims and the greater the overall level of harm to all spheres of society. Victimization of individuals causes harm to many others. such as their families, their friends, and community of origin. Numerous indirect victims are likely to mean many more indirect victims of the victim. The hidden transcripts of trafficking in persons, its victims' data and structural dynamics demand to be acknowledged and acted upon. Every day that passes without decisive action allows more children to disappear into the shadows, more families to grieve, and more perpetrators to evade justice. Having witnessed the devastation caused by trafficking in persons, I'm acutely aware of the scale of suffering it inflicts. It strips away humanity and destroys families and livelihoods. South Africa has a moral duty to lead efforts to combat trafficking in persons, not only within its borders, but across the continent, African continent. By uniting against this atrocity, we can dismantle, and we must dismantle, the systems that allow trafficking in persons to persist, ensuring justice for victims and rebuilding a society where such exploitation is no longer possible. I just want to pause here. This is not a pipe dream, my lord. This can happen. And I think it's important to know this is not just aspirational. We can do this. This is not just a global issue, but it's a deeply South African one. As trafficking in persons intersect with our broader fight against inequality and injustice, the gravity of this crime has shaken South Africa and many across the globe. We must therefore act boldly to end this grave violation of human rights and strive towards a society where human dignity and the safety of all children are prioritized. Yeah, that's the end of my report, my lord.
You don't need to go to the tables. They are merely the cases that was found by the witness.
Yes.
Thank you. Anything else, Ms. Winnipeg, from the witness?
No, my lord. I'm merely to ask the cases, but I think you have referred to this. This is what Dr. Beatrice Creer was able to also collate for you, meaning all of the cases dealt with in South Africa where there were convictions for trafficking in persons counts, both in terms of SORMA and the transitional provisions, and then in terms of the Pocket Act. Is that correct?
That's correct, Marlon, if that question is supposed to be. That is correct. Professor Beatrice Kruger has been just phenomenal in keeping tabs on these cases, and so that's correct, Marlon.
Thank you very much. Doctor, do you then confirm the contents as well as the correctness of the contents of your report?
I do confirm that, my lord.
Thank you. Thank you, my lord. That is the evidence of this witness.
Just for the record, I've also activated the automatic transcription function. So when you get the link, or if you had followed on your laptops, you would have seen a transcript appeared on your screens for counsel and their preparation. Thank you, Mr. Harmsen.
I don't have any questions.
Thank you. Ms. Mkabai.
Morning, my lord. I have questions.
Certainly.
Morning, Doc.
Sorry, my lord, am I being...
Yeah, you won't be able to see Ms. Mkabai, who represents Mr. Van Ryn, as there is no camera that shows that way. If you want to, I can turn my laptop around and you'll see in a distance. But you can just listen to the question and answer the question, please.
Sure.
Thank you.
Doc, can you hear me? will I be correct if I say you are being compensated for your testimony today?
Not that I know of, ma'am. I did not, arrangements were not made. I did not give an answer that I would be compensated. No, there was a fleeting mention of a possibility, and so no, I have no intention to request money for this testimony.
About your report? Any compensation about your report?
Just repeat that, ma'am. Sorry.
Are you going to be compensated? Or are you compensated already for your report?
Okay, so I will put it on record, ma'am. I will not submit an invoice for my testimony again. There was no agreement made in terms of compensation. It was barely discussed. It was a fleeting reference at the outset of the conversation. But I want to make it clear, I will not be compensated for this. I will not submit an invoice for my service to this. So the answer is no, I will not be compensated for this.
In cases of this nature, you primarily give evidence on behalf of prosecution and all government sectors. Will I be correct to say that?
Ma'am, I just want to repeat that. So you are asking if
Okay.
can you just repeat the question, ma'am? There's a little bit of an echo. If you could just repeat that, please.
I will do that, Doc, with pleasure. You primarily testify for prosecution and all government sectors in matters of this nature. Is that correct?
Well, I have the previous occasions when I provided testimony, I was approached by the prosecutor on behalf of the state to provide evidence. That's correct.
Who asked you to prepare a report in this matter?
Okay, ma'am, another breakup there. I'm sorry. Can you just repeat that?
Doc, who approached you and requested that you must prepare a report in this matter?
Sure. Well, I was approached by Advocate Swanepoel, so, and yes, and I responded accordingly.
Was this the first time you received a request of this nature from Ms. Swanepoel?
That is, to the best of my knowledge, yes. I have previously worked as a police investigator where Mrs. Swanepoel and I have worked together on matters of sexual offences, but with regards to a matter where Advocate Swanepoel is a prosecutor and I'm asked as a non-member of the South African Police Services to come in and to provide this kind of evidence. This is the first time with Ms. Swanepoel. That's correct.
Thank you very much, Doc. You can therefore safely say that you know Ms. Swanepoel before the request of the report in this matter.
Oh, I absolutely do. I know Ms. Swanepoel. Ms. Swanepoel is part of she's just been a phenomenal leader in the space on all things human trafficking. Everybody knows Ms. Swanepoel in the human trafficking space. She's done phenomenal work in prosecuting trafficking matters. She's an incredible source of knowledge. She's well respected for her integrity and just subject matter knowledge and institutional knowledge for working in this space over a very long period of time. So yes, I definitely knew Ms. Advocate Swanepoel before this matter.
Thank you, Doc, for that profile, although I didn't ask for it. Your background is primarily academic. I can Your background is primarily academic.
I would say everything but primary academic, ma'am. Everything but. I'm more than happy to explicate that if you would like me to. But as if you've received a copy of my CV, academia is but one part of it. So what I do now and what I constantly do, and that's also the reason I have included a kind of a summary essence of the people in the field currently, is constantly checking and rechecking and verifying. But to your assertion that it is primarily academic, it started off in the police. After that, that was for 10 years, and then for 10 years I was in academia, and at the same time working with the National Freedom Network, part-time, gathering information, intelligence, helping people compile case dockets. So it's definitely not just academic, it's the theory, or as they say, the theory informs the practice and the practice informs the theory. You cannot have it any other way. So that would be my response to your question, ma'am.
Thank you, Doc. Have you worked directly with the victims and or accused in human trafficking matters and kidnapping matters?
I just want to make sure that I get the questions. Have I ever worked directly with human trafficking victims and perpetrators?
Yes, Doc, that's my question.
With hundreds, ma'am, literally hundreds. I could go into detail why I give you such a big amount. I will state that again, hundreds over this 23 years. From investigations, a lot of the work that I've done in the field, I can use one example. I mean, there's so many examples to use, man, but I'll just use one example in 2007 when I referred to the Janice Kapora case earlier, and we did 2 trips in April and August 2006. So part of your investigation is you spend time in the field. I've been in brothels as well, been in places where you speak, you work with people, you know when you are working with victims. Part of my research has also included survivors of trafficking. I've done interviews with traffickers, convicted sentence traffickers. They've spoken to me about things like, all manner of detail in terms of decision making, how people are trafficked, why people are trafficked. There's an entire conversation, man, that I'm able to provide there. But to your question, yes, ma'am, I've worked with countless victims of trafficking and perpetrators and convicted traffickers.
Is it fair to suggest that your perspective is more focused on advocating for victims?
My focus is on advocating for victims. Well, I think any reasonable person so firstly, there's a methodical process. Let's talk about research first. I'll just respond to that. So when we talk about the SKEET principles, yes, over the last 23 years, we're talking about skills and knowledge, education, experience and training. When you have all of this data, and the data clearly tells you that trafficking in persons is a heinous crime, clearly tells you that from my own experience, how many victims are harmed, how many survivors or victims of trafficking I've lost personally to suicide. There is no way that a person with my experience and knowledge cannot in one way, shape or form also advocate for victims. It's just not honest, it's not fair, and I think it's the just thing to do, that when advocacy for a victim or a survivor is needed, that as a reasonable person, it's the right thing to do, man.
You do advocate for victims, Doc?
Just repeat that question, ma'am.
From the answer you've given, it is clear that you do advocate for victims.
Okay, so do I advocate, is there a specific aspect to that that you are
in cases of human trafficking and kidnapping, do you, most of the time, advocate for victims?
Do you mean, just a moment, Dr. Van der Walt, just one moment. Do you mean by that he always sides with the victims? Just to simplify it.
Not
Because advocacy, as he says, it's a wide term and it encompasses a lot of issues. So maybe be more precise, because it's clear that there's a misunderstanding between the question being posed and the understanding of the witness. Because we don't need to have a long thesis on the broad spectrum. So maybe if you want to be more focused on the question, pinpointed, and then the witness can answer. The way I understand the question is, you want to know whether he takes the sides of victims.
Not in that manner, my lord. My question is...
Then maybe ask the question so that I can also understand the question, because it's clearly I also don't understand it.
Okay, thank you.
Thank you.
Doc, did you understand my question?
Well, I'm trying to, ma'am. I'm just going to try and focus on this case. The case that we are here in court today is, the court is charged with a duty to weigh up the interests of, the victim, the society, and the accused person. And, clearly we don't know the whereabouts of Joshlin in this case, but clearly the accused has been found guilty. So if advocating, if I'm inferring what you mean by advocating, means that highlighting that very, very, very real harm, physical, emotionally, psychological, may have been part of Joshlin's fate, and ordering the court to take that into consideration, that is what I'm conveying here.
Did the court still want me to paraphrase the question?
No, you can ask the questions any way you wish, as long as it's clear. I'm just waiting.
You testify that you didn't personally interview the victim. The victim in this case is Joshlin. Is that correct?
Okay, there's a bit of a break there, ma'am. If you can just repeat that again, I would really appreciate that.
Okay, I'm sorry then. You just testify that you did not interview the victim, and the victim in this matter is Joshlin. Is that correct?
That's correct, ma'am.
Do you know where the victim is? Do you know the whereabouts of the victims?
It's a question whether I know the whereabouts of Joshlin.
Yes, Doc.
Ma'am, I don't, and I think that is a question that the world is asking at this very moment. And I do hope that we find out sooner than later.
The reason why I'm asking you this question, Doc, is because I'm going to paragraph 12 of your report.
Is that the one on page 17, Sinkabai?
Yes, my lord.
Thank you.
Sorry, my lord, is there a question at the moment?
Yes, Doc. There's a question coming.
Okay.
Doc, I'll pose the question just now.
Okay.
In this paragraph, it is 12. The topic is sentencing.
Yeah.
You have listed the factors that the court has to look at when considering a sentence in human trafficking and kidnapping matters. My Lord, can I have my laptop?
Certainly, certainly.
My Lord, may I ask Ms. Kabai is getting a laptop just to correct what was just put to the witness. The factors listed here are the factors listed in section 14 in the Pakotip Act. It comes from the Act as it stands, and it only refers to trafficking in persons matters, because that's why it's the Pakotip Act, not kidnapping. So to lump the two together is incorrect. It's the factors that are listed in section 14 that the court must consider when deciding on an appropriate sentence.
Yeah, let Ms. Nkabai ask the question now that she has the laptop. Thank you, Ms. Nkabai.
Doc, can we go to your paragraph 12 of the heading sentencing?
Yes, ma'am, I'm there.
I will read this paragraph. The evidence before the court presents a substantial aggravated scenario with several important factors to consider. The consideration of these factors within the context of the national attention and the egregious nature of the crime underscores the importance of protecting vulnerable victims and society at large under the Prevention and Combating of Trafficking in Persons, Pakotip Act 7 of 2013. Section 14 of the Pakotip Act provides aggravating factors that the court must consider, which include, but is not limited to, the following: the significance of the role of the
Listen,
convicted.
Kabai, is it really necessary to read? You can just refer to the paragraph and ask the question. Is it really necessary to read the whole paragraph?
I'm not reading the whole paragraph, my
Now
lord.
ask the question, please,
I'm going
because
to the
it's
question.
there. Just ask the question.
In paragraph A states the significance of the role of the convicted person in the trafficking process. Now, when we tie that paragraph A with the evidence in this court. Is there any significant role that you know that the accused persons before this court they've played?
Sorry, my lord, there's a little bit of a breakup. My understanding is that the question revolves around section 14A, the significance of the role of the convicted persons in the trafficking process. So if that is correct, I know that there's a question that follows. I just want, if that question can just be repeated, I'd really appreciate that.
The question was whether you're aware of what role the accused persons, plural, not only relating to Ms. Nkabai's client alone, played in relation to that factor. You've discussed all these subsections under 13 of your report. And I thought that in reading the report the other day when I received it and listening to your evidence this morning, that's where you set it out. Or am I wrong?
That's correct, but not all of these are covered though. The ones that follow
No.
13.
After you listed A to L, you said in the report, considering the case before the court, the relevant factors will be considered and it will be blended. And then on the 13, you then deal with all these subsections that's relevant to this case. And then you discuss the evidence and the role played by the accused, plural, in the matter. That's how I understand it. So, for example, when you deal with the significance of the roles played, it's to be found at the bottom of page 18 of the report, where you say in terms of section 14A, and then you deal with that, and then you say the facts show, and then you proceed and it goes over onto page 19. That's how I understand the evidence.
That's correct, my lord.
And that's what I saw in the report and in your evidence that I heard this morning. And there's a lot of repetition, of course, because it's not limited to one factor or the other. Sometimes it overlaps.
Yes.
Good. Thank you, Mr. Kabai. You may ask the question. Because I don't know whether you and I are looking at the same report. Because if you just turn the page, you see the whole discussion from where we were.
I'm still going to the discussion, my lord.
Now just get there, please.
I'm still on paragraph 12. My question is pertaining subsection A of your paragraph 12. The list of those conditions or those circumstances or factors, those are the list from the Act. Pakoti. Now my question to you is, can you tie subsection A to the facts of this case, the case of Joshlin?
Did you hear the question?
The question is tying subsection A to the facts of the case. Is that correct, my lord?
Yes.
Yes, my lord. So I can do that. There's a big focus, obviously, on accused 3, but the roles of accused 1 and 2 and the 204 witness was clearly explicated in the heads of argument and the summary of the different testimonies by the witnesses. So whilst that was not done in that granular detail, that's definitely something that that we can talk through. That will probably require just to pull up some of these testimony summaries that I have access to, my lord, and I'm happy to work through that. But very clearly that there was obviously all 3 accused 1, 2, and 3 was convicted of these crimes. Accused 3 was clearly where this germinated, where this started, and accused 1 and 2, and by extension with the 204 as well, go through each one of these accused and how that relates to subsection A, my lord? Is that a question there?
I don't know. You can repeat the question or clarify it, Mr. Kabai, so that I also know.
Paragraph 8. As one of the factors or circumstances from the Partnership Act, 1. The significance of the role of the convicted person in the trafficking process. Now I'll limit my question. I'll make it very clear and brief to you. Do you have any evidence that my client, Mr. Van Rey, played any significant role in trafficking of Joshlin?
My Lord, may I please object to this question? My Lord, the witness clearly deals with this as explained in paragraph 13 in the pages to follow.
Well, I'm going to allow the question, and it's up to the witness to refer Mr. Kabai to the report that we all had.
As the court pleases.
Thank you. The witness may answer the question. Objection is overruled.
Sure. So my response to that was that, again, I think I would refer to the mosaic of evidence and the constellation of circumstances, the issue of common purpose, that there was clearly a cohesion there that implicates accused two as well. I mean, it's probably a separate conversation about the degree to which accused two was in the weeds of the planning, but I think from the evidence that I had access to, my lord, all three accused were convicted, and again, constellation of circumstances, and accused two was an active part in that calculation.
Thank you, Don. Let's go to B. Is there any evidence before this court that Mr. Van Rey has a previous conviction of trafficking in persons?
A previous conviction? Not that I'm aware of, ma'am. No, I don't have any reports that I have access to about any previous convictions by any of the accused.
You haven't seen the victim, you haven't interviewed the victim, you don't know the whereabouts of the victim. Now let's go to C. C is whether the convicted person caused the victim to become addicted to the use of the dependence producing substance.
Ms. Nkabai, on what basis are you asking that question? I'm asking you a question now, so you may answer me.
On the basis, my lord, that I want to know whether the factors that are listed on the Partnership Act, there are about 15 factors, are they relevant? Or is there any evidence proving those factors in this
The
case?
witness never mentioned a word in his analysis on sub C. If you have read the report, which I hope you did, he deals with A, J, F, G to an extent, and I, and he interblends that. That's in the report. So the question you ask is not allowed because it's not part of this witness's evidence. And it's clear, question was already asked and answered, the context of listing the factors from A through to L. The question is disallowed. For the reasons I've given.
My Lord, even if the court is saying this is not in his evidence, but this is his report.
I have made a ruling, Mr. Kabai. I'm disallowing the question.
Thank you, my Lord. Can we go to D?
What about D? What about D, Ms. Kabai? You haven't asked the question.
Doc, there is no evidence before this court as to how the victim is kept. Because the whereabouts of the victims are not known. You haven't interviewed the victim yourself. Any comment on D?
Yes, ma'am, I've got a comment on D. I'm just gonna take 2 steps back, ma'am, and so I just want to make sure we're on page 17, and on that page, I am referring to section 14. Now, these are the factors that the court must take in consideration, and the court is not limited to these factors. So, what I've done here, ma'am, I was merely providing the rubric that is in the back of the pack. So, whether these factors are all relevant or not, all of them are there. So, what I've shared with the court is these are the factors, and then based on the facts in this case, I would select based on which one of these factors are relevant. Those are the ones I've discussed. So clearly, D is not relevant to this case because, again, that information is just not available to me or to the court. So, just to clarify those, that's really the framework. And then what I've discussed in my report are only the relevant sections, not all of them, not all A to I, if that makes sense, ma'am.
I don't agree with your answer, Doc. On the following basis. You are an expert. And taking from your last paragraphs, you were furnished with the evidence in this matter. Now, my question is, from the evidence that you were furnished with from this matter, what will be your comment on paragraph D?
The question is disallowed for the same reasons that I've disallowed the previous question relating to an irrelevant subsection of the Act, and the witness had just explained he didn't deal with it in the report, nor in his evidence. Are you padding for time, Mr. Kabai?
I don't appreciate that kind of comment from the court.
I'm asking you.
I am a litigant. I have prepared my cross-examination for this witness. I cannot come here to buy time, my lord, with respect.
Because, and I'll explain to you why I'm asking you the question. I've just disallowed a question on an irrelevant factor. And you repeat by just referring to another irrelevant factor. Just focus on the relevant issues and on the evidence of the witness. You started out this morning by making a suggestion to the witness that he was compensated. It was not a question, it was a statement made to the witness. And it turned out it was unsubstantiated. Let us focus and deal with the relevant issues and on the evidence of the witness. I hope I've made myself clear. Thank you. You may proceed.
Can you go to paragraph 13? Paragraph 13 of your report, Doc. The heading there is discussion on sentencing considerations.
Sorry, ma'am, if you could just direct me again to where you would like me to go to in the report.
Are you in your report?
I've got it in front of me, ma'am. If you could just kindly...
Paragraph 13. The topic of paragraph 13, 1-3, yes.
Yes, I've got that, ma'am.
The topic there is discussion on sentencing considerations. Your first sentence there is, the overwhelming majority of trafficking cases involve significant planning and deliberation on the part of offenders. That statement is general. Will you agree with me?
That's what it says, ma'am. That's correct.
Okay. Let's go to sentence number 2. We start with, the case demonstrates clear evidence of planning and premeditation. Which case are you referring to? Are you referring to this case of Joshlin? Because you just said the case.
No, I'm talking about the Joshlin case, ma'am.
Come again?
I'm indeed referring
Okay.
to the Joshlin case.
Okay. Now let's go to planning. When you say this case demonstrates clear evidence of planning, what do you mean?
Well, I think the fact, planning is the literal meaning of the word, denoting that this, the idea was clearly ideated several months before Joshlin's disappearance. So there was obviously a demand that was identified. There was, the talk about the money. There was a date, a time, and the evidence suggests that over a period of several months that Hughes 3 was planning something. I mean, her conversation with, I think it was, conversation that happened in August, that the previous year. I just want to get the name of the gentleman, Mr. Stephen Kutsia, for somebody to, for Q3 to say that, that something is coming down the pipe, something is going to happen. So there, clearly there was a fair amount of premeditation that happened months before that. There was a meeting with the person in the white polo. There was communication over an extended period of time. There was conversations about money. There was a time at which Joshlin was going to be picked up. All of this implies that there was a fair measure of plan. It's not like any of the accused or accused 3 woke up in the morning and just decided, well, today I'm going to sell Joshlin. No, there's evidence that there was a protracted period where this idea was germinated. I mean, there's several other questions that could be asked, but so I think that would be my response to your question about planning, ma'am.
Regarding this alleged planning you are talking about, did you have an opportunity to interview the accused persons before this court?
No, I did not interview the accused persons before the court. I listened to the judgment, the summary of the testimonies, and the finding of the court based on the evidence that there was, a common purpose that from which Joshlin's disappearance emerged. So that would be my response to that question.
Okay. Is your conclusion about the planning based on direct communications among the accused person before this court?
Direct conversations.
Direct communications.
Communication.
Such as, do you have the messages amongst the accused person before this court where they were discussing the planning you are talking about?
No, I don't have access to those messages, ma'am. I'm sure it's very, very likely that there was messages. It's very plausible, overwhelmingly so, but I don't have access to it.
Do you have...
Just one moment. Dr. van der Walt, you may or may not know, if you had listened to the judgment, there was no evidence of messages in this case. None was laid.
Okay, so we are talking about text messages and telephonic communications, right?
That's what I suspect. But there was no evidence of messages between the different accused in this matter. No evidence was laid.
Noted, my lord.
Yes, Doc, there was no evidence before this court proving planning with messages, with any recorded conversations or any emails amongst the accused person before this court. So what I'm putting to you is that you cannot, with certainty, come and write in your report that it is clear that the accused person before this court planned and premeditated the alleged offense.
Well, ma'am, to the fact that communications is not available, wasn't found, planning can still happen without a cell phone and without email. It's very clear from the kind of the ecosystem within which all of this happened that it's not a very big community. These were people that spent a fair amount of time together, but also just the evidence that is available is that there was interaction between all of them, and accused 3 made no plan. So I would argue that there was, I mentioned that in the overwhelming majority of cases, there is a fair measure of planning to make this happen, and I would argue that that is the same that transpired in the Joshlin case.
Do you perhaps have the words that were used in this planning, the deliberations? What was it that was planned? Do you have that evidence at your reach?
So, ma'am, you are asking, I'm just trying to, there's a little bit of a breakup. You're asking whether actual evidence of the actual planning, is that what you're saying?
Yes, Doc.
Well, well, the detail of the granular detail is, I think what is available is from the testimony of Mrs. Lombard and Mr. Gutsia. Again, the constellation of circumstances here, clearly, this would not be possible without a plan. It's just, there's no universe that exists where some form of planning and deliberation did not exist. Otherwise, Joshua would still have been here.
I will leave that, Doc, for argument. Use in your report, you stated that this alleged offense was motivated by financial gain. Why do you say that?
Well, I think the evidence that came to fore was clearly that there was money was clearly part of the equation here. So yes, I mean, one could argue further in terms of the socio-economic environment and some of the conversations accused three had about, I'm probably paraphrasing, a terrible family life, etc. There's also questions about why, the Andrews family, caring people who offered to take care of Josh, why Kerry did not make use of that opportunity. So a lot of questions, but clearly there is money involved here, so there was clearly a financial motivation. Yes, like with any trafficking case, there's always some benefit, and in this case, it's clearly there's a financial component to it, ma'am.
Thank you, Doc. Can you point to a specific evidence in this case proving a receipt of monies, especially by my client, proving transfer of monies, proving payment that indeed support what you just said?
Just for clarity, Dr. van der Walt, Ms. Nkabai represents Mr. van Ryn,
Yes.
and not Ms. Smith, so that there's no misunderstanding.
Yeah.
So when the question is a client, it's with reference to Mr. van Ryn. And of course, I see you didn't mention in your report that he himself made a statement about money that I admitted as evidence. But it's not in your report. Can you hear me? You haven't dealt with, in your summaries, you haven't dealt with the statements made by Mr. Apollos and Mr. Van Ryn that I admitted. So in the mosaic that you refer to, there is in fact evidence before the court from their own mouths that I admitted that money was going to exchange hands.
Okay, noted that.
Just for clarity.
Yeah. Sure, noted, my lord. Thank you for that. Yeah, I do think the financial component here is, I think it's disingenuous to ignore that. It was clearly a part of this equation.
Doc, I didn't hear clearly your answer to my question.
Can you just repeat your answer, Dr. Van der Walt? I am fortunate, and you would have seen that I'm not making notes as usual, because I have a verbatim transcript of what's being said on my screen. And after I've given the explanation, I must just pause it there before it runs on. With reference to the financial component, after I explained the evidence, he said it would be disingenuous to ignore that. And he went on, but that was the gist of the answer. Just for a counsel that also gets this transcript, you will realize it picks up on Ms. Swanepoel's laptop. So from the cross-examination, wherever it says Zelda Swanepoel, Z1 external, that's the cross-examiner that asked the questions. Just on the transcript that you get. Thank you.
Doc, if I can repeat this, on page 19 is paragraph 35. It's your last paragraph on page 19.
Yeah, it's line 35 on page 19.
You've written this sentence in bold letters. The crimes committed were motivated by financial or material gain.
Yeah. Well, that's correct. That's the argument. That's part of my opinion, ma'am, that there was clearly money involved here. And I'm looking at Ms. Lombard's evidence. She did make mention of all accused persons that will receive money and to keep quiet. Accused, I think Ms. Lombard, 1,000, accused to 1,200, and the rest will be divided between accused 3 and 1. And the reason for the payment is to ensure that they keep quiet and not tell anyone about the plan. So again, I think it's just underscoring that there was, that there was clearly a financial motivation here. So that's my position on that matter.
So your opinion is based on second hand. It's based on what Section 204 has said. In your possession, you don't have proof.
Well, yes. That evidence did come from the Section 204 witness as well. Yeah, it did come from the.
It was also in the judgment, Dr. Van der Walt. So it came second-hand from me in my judgment.
Doc, do you have an opportunity to review the whole transcribed record of this case? Did you have that opportunity?
Ms. Sinkabai, but there is no transcribed record. There is no transcribed record.
I'll rephrase my question. Doc, did you have an opportunity to go through the record of this matter?
What record, Ms. Sinkabai? Ms. Sinkabai, I'm not, the witness should not answer the question. I first want clarity. What record are you referring to? Ms. Sinkabai?
My lord?
What record are you referring to?
The record of this matter.
What record? Because as far as I know, there is no record that is available yet.
Thank you, my
What
lord.
is available would be all those, how many days of, it would be 36 days of evidence that were uploaded on Teams. It was not transcribed. And of course, unless somebody would have had my handwritten notes and called that a record, the only portion that was transcribed so far that I know, and it has not been signed by me yet, is the judgment. And the reason why I haven't signed off on it is because the transcribers had some spaces in between. And we need to re-listen the recording. I've got my notes on the judgment, but I didn't read it out verbatim as I wrote it.
Thank you, my lord. Doc, I will rephrase my question. From which evidence did you use to prepare your record?
Ma'am, I listened to the judgment. I also received the heads of arguments and the summaries of the testimonies that was provided to me in preparation of my report. So that is what I used and relied on.
When you say heads of arguments, are you referring to heads of arguments from the prosecution side and the defense side, or from one side?
Well, I was supplied with relevant documents by the prosecution, and again the access to the judgment was publicly available, and so that is what I relied on. That would be my response to that, ma'am.
You mentioned, Doc, heads of arguments. My question is, these heads of arguments, were they coming from the prosecution side or from the defense side?
Well, ma'am, I'll just refer to just with all the previous cases I've provided testimony with over several years and working with several prosecutors. The heads of arguments for the state has always been one of those pieces of information that's supplied to me to prepare a report and my testimony. So in this case, very similar to previous matters, I received the heads of arguments from the state.
As far as I know, you didn't end up heads of argument, Mr. Kabai.
As far as I know, my lord, I handed 2 bundles.
No,
The
I'm
first
talking
bundle.
about the heads of argument in the final case, because you had it with you when you argued, and you will note the document that I got says for the 174 discharge.
I emailed the second bundle of heads of arguments with the corrected topic on the very same day, my lord.
Yes.
I followed the protocol that this court has given me, that I must email my heads of arguments to the register. I did that on the very same day, my lord.
Carry on.
Thank you, my lord. Back to the issue of financial gain, Doc. Before this court, there's no evidence of any bank records or financial ledgers linking my client to any benefits.
The question is disallowed because the witness did not testify to that.
The witness did not testify to that, my lord.
Yes.
But the same witness, in paragraph 35 of page 19, boldly says the crimes committed were motivated by financial or material gain.
So what? You asking about bank records and stuff. He never said anything about bank records. And if you look at that paragraph with the financial gain, I want to know, where do you see your client's name in there? In that whole paragraph. It goes over to the next page at line 15 or 14, because there's a space, a double space. Except when he deals with it, he says all 3 of the accused knew or should have reasonably known that Joshlin was being sold for exploitation, and they stood benefit. Nothing about bank statements, other financial transactions where there's a paper record. He never testified to that.
I agree with the court, my lord.
Yeah.
He never testified as to the bank records. This is the question from the defense.
The question is disallowed. I've disallowed it, I've made a ruling.
As the court pleases, my lord. Therefore, Doc, I disagree with you when you say the alleged offense was motivated by financial gain without having been given or having been filed before this court proofs to the same.
The question is disallowed. It's argument, it's not a question.
Thank you, my lord. Still in your report, Doc.
Page.
I just wrote this by my hand. I'm checking it here.
The page number's at the bottom of the page, and we can't always see it on the screen. Page number? You want to go to the report? Page number?
You will assist me, Doc. There is in your evidence where you mention that there's a clear evidence that the accused person before this court, they should have known. Or they sold Joshlin for exploitation. If you can point out from your notes.
That's the portion I just read. It's on page 20. Starts at about the third line from the top. I had just read it before this. When I said that's the place where he speaks of all three, the accused, with reference to the fact that Mr. Van Ryn's name is not mentioned in that paragraph.
It's not this part, my lord. There's a part when he said it's clear.
The question.
It's not this part.
It says, furthermore, all three accused knew or should have reasonably known that Joshlin was being sold for exploitation. That's the part where it says that. Page 20, line 3 of the report.
The sentence I saw was not phrased in this manner. I'll come back to it later.
He used exactly the same words when you asked the question. Whilst you're looking, Ms. Nkabai, I'm going to ask the witness a question. Dr. Van der Walt, can you hear me?
Yes, I can, my lord.
I was told in chambers this morning that you have another commitment at approximately 3 o'clock South African time. How long will that commitment take?
I've got no idea at this moment, my lord. It's dealing basically with the home affairs on this side, so it could be an hour, it could be 2 hours, but definitely not the whole day. Yeah.
No. So what we'll do is that if 3 o'clock comes and you have to go to that commitment, I will excuse you, and then you'll have to come back. It will be evening our time, but you'll have to come back afternoon your time, US time, because we will finish your evidence today, even if we settle dark. Good? Thank you, Mr. Nkabai.
Thank you, my lord. And there. Doc, you will correct me if I'm wrong. You said something about the 3 accused in this case having knowledge that Joshlin was being exploited or was being sold for exploitation. You'll correct me if I'm wrong.
That's what I just read to you. It is there in the report. I read it twice. So he doesn't have to correct you because it is there.
Do you know who are the exploiters?
I don't know who the exploiters are, ma'am.
Do you know who were the transporters?
The transporters.
Yes.
No, ma'am, I don't know who the transporters are.
Would you agree with me that in human trafficking and kidnapping cases, identity of the transporters and exploiters is very crucial in confirming exploitation?
Just one moment. Just one moment before you answer. You might have a PhD, but I didn't hear that you have a legal qualification. Do you have a legal qualification, firstly?
I would respond to that question.
No. Opinion evidence is inadmissible unless it's qualified. You've been asked to give an opinion. And you've been asked to give me a legal opinion. The question is this allowed? Deals with the elements of a criminal offense, which is not for this witness to tell me what it is. It is for counsel to address me and then for me to make a finding. And I thought we had gone beyond the conviction stage. We're now dealing with sentence. And this witness gave specific evidence, not dealing with the law insofar as it relates to the elements of a particular offense. These are the reasons that I have disallowed the question. You may proceed, Mr. Kabai.
Doc, what specific evidence do you have that made you to say the accused person before this court sold Joshlin for exploitation?
So the question is, what evidence is there before the court that the accused is a person or person? If you could just clarify that, but the question relates to that Joshlin being sold for exploitation. Is that correct, ma'am?
That is correct, Doc.
Well, I think that's the conclusion that was reached by the court, and trafficking, just the very definition of it. There's always a purpose, and the purpose is always exploitation. So the fact that I think exploitation is implicit to the definition, and that is what the accused persons have been found guilty of. So that would be my response to that question.
Still in paragraph, still in page 20, Doc. I suppose this is the last paragraph, is starting with the victim in this case.
So it's line 36 on page 20. Yes, Kabai.
The victim in this case, 6-year-old Joshlin Smith, very likely, open brackets, plausible, close brackets, suffered abuse.
Is that a question, ma'am?
No, it's not. I'm waiting for the question.
Doc, please explain. What made you to come to that conclusion?
Well, again, ma'am, in the 23 years that I have been working with these matters, I have never, I don't know of any recorded case of human trafficking anywhere in the world where the victim in a trafficking case did not experience some form of abuse, physical and psychological, even more so in the case of a 6-year-old. As I mentioned in my report, it would be disingenuous to assume that she was placed in such a situation merely for admiration, because of her beautiful eyes and her light-colored skin. I think abuse, physical, psychological, is implicit in exploitation. So that is, again, considering not just research, but just the current day realities in South Africa. These cases never do have a good outcome. So that is my view there, my position there.
You know, Doc, the reason why I'm asking you this question. You didn't see Joshlin. You didn't interview her. We don't know the whereabouts. We don't know the surrounding circumstances during when he was being trafficked. We don't know the traffickers. Now you come, you say.
He doesn't know the traffickers, but we know they're here because I convicted them.
We don't know the exploiters. But you come, you say, as if you were present, you come, you say, very likely, Joshlin suffered abuse.
Where's the question?
That is the question, my lord.
That's not a question. You told him that he can't say. Now, where's the question?
I'll repeat my statement, Doc.
So, in other words, you put it to him. What you're now going to tell him, you put that to him as a fact. I see. Then do that.
It is in your testimony, Doc. And it's common cause. You didn't interview Joshlin. Joshlin's whereabouts are unknown. Now, when you say, very likely, Joshlin suffered abuse, were you present when he was being trafficked?
No, ma'am, I wasn't present when Joshlin was trafficked.
Did you have access to any medical records or psychological assessments where you could come and say, because of these medical records, because of these psychological assessments, Joshlin very likely suffered abuse?
Yes, my lord, so my answer there would be verbatim as I've written it in the report. The victim in this case, 6-year-old Joshlin Smith, very likely, plausibly, suffered abuse that came both at a physical and psychological cost. That is my position, my lord.
Doc, you use the phrase very likely. Would you agree with me if I say this indicates some level of uncertainty from your part?
I just want to make sure I heard the question, ma'am. You are asking whether my statement or my phrasing of this position implies some level of certainty. Is that correct?
Just
Uncertainty. Uncertainty.
Oh, uncertainty.
That's the statement put to you.
Sure, I received that. I think my answer there would be, again, the accused person was convicted. You know, exploitation is fundamentally part of a trafficking conviction. The court has clearly weighed up, and use the word again, the mosaic of evidence and the constellation of circumstances that this is in fact, that Joshlin was sold. Exploitation is implicit in all of that. So, yes, that would be my response to that question. I would augment that. I don't think there's, an observer of this proceeding or this trial that would not want a Joshlin, coming to the fore. I think that is something we all hope for and wish for, but I think the current evidence on record, the fact that the accused did not respond to these very serious charges put to them, so there's clearly adverse inferences to be drawn there, and we are left with no other logical conclusion that Joshlin was sold, and ultimately exploitation against is implicit in the definition of trafficking.
Thank you, Doc. Therefore, it is safely fair to say your opinion is a hypothesis based not on direct evidence. It's a logic, you just said.
Well, the court weighed up all the evidence, and this is the conclusion that the court reached. So, clearly there is no evidence available, real evidence in terms of Joshlin's whereabouts and what ultimately happened to her. But this is what the court found, and congruent with how trafficking happens in the real world. This case accords with how trafficking happens. When we think about acute vulnerabilities, we think about the issue of planning, we think about the financial incentive, and also the range of ways in which people can be exploited. There is a coherency in these arguments and in the evidence that the court obviously weighed up, and they were found to be guilty. So I would stand by my report on that point, ma'am.
With certainty, can you say Joshlin was abused?
My answer there is that exploitation is implicit. Any and every form of exploitation that's ever been documented in case law anywhere in the world, there does not exist a victim of trafficking, a minor or an adult, where there's not some form of harm that has befallen them. So, yes, and and my framing there, I stayed with the articulation there that abuse suffered physical and psychological came at that cost, very, very likely. But again, it's implicit in the crime of trafficking in persons, exploitation, and there's always harm in exploitation.
So, Doc, your conclusion, while based on your experiences and your expertise, but ultimately relies on assumptions
My response to that.
Yes, you can continue, Doc.
Can I continue, ma'am?
Yes, you can, Doc.
Yeah, well, I think we've got a body of knowledge from a jurisprudence perspective in terms of just in South Africa, how trafficking happens. I went into some depth about the state of affairs in South Africa, gender-based violence, the acute vulnerabilities of children, and obviously the court considered, and I'll use that word again, a mosaic of evidence and a constellation of circumstances. The accused persons have been convicted, and again, exploitation is part of this crime. And I've never seen a case where, of this nature, and specifically in this kind of this socio-economic ecosystem within which trafficking happens. There is no universe where I see harm not befalling Joshlin Smith.
Without repeating that question, Doc, I will argue that those are assumptions.
Mm-hmm.
Yeah, ma'am, so my response would be, there is no real evidence that, that's tangibly being presented on that point. I think at the end of the day, it's, again, what the mosaic of evidence in this case, the nature of how trafficking as a crime occurs implicit in that is exploitation. So, I will just keep to the verbiage and the articulation in my report.
I agree with you, Doc, fully. There is no real evidence before this court.
Ma'am, the court
Proving all the elements, proving all the elements.
Just let the witness finish his answer. Dr. Van der Walt, you may finish your answer.
Sure, well, again, the crime of trafficking in persons has been proven. I mean, the exploitation is implicit in all of this. The court has weighed up the evidence that has been presented, and this is where we are at. Exploitation is part of the process of trafficking, and this is what the court found.
Thank you, Doc. I'll go back to your first part of your answer. I agree with you fully. There is no real evidence before this court proving not even a single element of human trafficking and kidnapping.
I really wish to object to this. We are in sentencing proceedings. The court has made a ruling. We are not in an appeal process now. We are in sentencing. My Lord, please, may I object to this line?
Yes. Comment,
Nikki.
Mr. Kabay?
Yes, my lord. I was just making a follow-up
No.
to the witness
No,
answer.
respond to the objection. Respond to the objection that was raised as we normally do. It's the Audi rule. So she objected, so respond to the objection.
I've already answered, my lord. I was just...
No. I want you to answer to Ms. Swanepoel's objection. You're putting it to the witness that there's no evidence of human trafficking before this court. She's objecting on various bases and make a side comment, but really, we on sentence stage here, in any event, whatever the witness says, it's irrelevant insofar as it relates to my findings on the conviction. And then she adds on, we are not at the appeal stage. So I want you to answer to the objection so that I can rule on it.
My answer still remains, my lord.
What is the answer?
I am making a follow-up on the witness response.
No, but she's objecting to the follow-up. So I'm asking you to answer to the objection.
I'm answering to the objection, my lord.
Have you answered to the
Yes.
objection? There's no answer then. Objection is sustained. Question is disallowed.
Thank you, my lord.
Just one moment. Oh, there I'm back. No, I just lost the connection with the teams, but I'm back now. Thank you. Ms. Nkabai, whilst you're reading, is a social worker back, Mr. Peterson?
Yes, my lord. he is.
Now, clearly we're going to have a break. We're also going to have a lunch break. How far from here are your offices? Is it the one on the corner?
No, about 15 minutes drive, Fredenberg.
15 minutes drive.
Vredenburg, my lord.
I think go back to your office. Now I'm excusing you. This morning I didn't. We will give you a call to indicate to you what time you should be back. If it's tomorrow morning, we'll also tell you this afternoon really what time tomorrow. And if you have a delay, give us a call. You've got everybody's numbers, right? Don't leave a note on the table and disappear.
No, my lord, there was no delay this morning. I was not informed that I had
They didn't inform you.
no one.
Okay, so just calm down. You don't need to show me attitude. We'll give you a call. I just don't want you to sit here and then 4 o'clock arrive and then we don't get to you, you've wasted your time. Go back to your office, do some work or go and have lunch and leave your cell number with us so that we can call you. Do you have the cell number? Somebody must just get the number. Thank you. Thank you, Ms. Nkabai.
Thank you, my lord. Doc, it is in your report that you stated that the accused knowingly commodified Joshlin, prioritizing their financial motives over her well-being and safety. My question will be on commodity.
That comes from the judgment. That word comes from the judgment. That was a finding I made in the judgment when I said they commodified Joshlin.
Is the witness going to answer to this?
No. I've disallowed the question because I told you.
Okay.
It's not him that said it, I said it. And I told the parties on Friday, if you have issues with my judgment, you'll have the opportunity to apply for leave to appeal on Thursday afternoon. Because I see in the reports that it's been said that I convicted the accused because I was biased. And I invited the parties to make their 317 applications.
My Lord?
The question is disallowed. The commodities that he spoke about came from me. Ask the next question.
I was not going to answer to put that same question to the witness, my Lord. You mentioned something like I'll read it from your report. There was clearly a common purpose.
Which page, which paragraph? So that I can go there.
Paragraph. There was clearly a common purpose.
I think it said at more than one.
It's under paragraph 13, discussion on sentencing consultation.
Yeah, but which page?
It's 21 or 22. It's below paragraph 20.
So is it 21 or 22? Is it under 14?
Page, let me check the page. Page is 18.
Page 18.
Paragraph 21. A paragraph below paragraph 20.
There was clearly a common purpose. Yeah. Yes, I'm there.
And agreement among the three accused.
And Ms. Lombard.
And Ms. Lombard. Will the next question on this piece of evidence be allowed by the court, my lord?
Sorry?
Will the question on this...
you haven't asked the question. You've taken me to that.
Okay.
That sentence, so ask the question.
How did you come to this conclusion?
About the common purpose and the agreement. So it'll be line 22, if you're with us. Page 18. There's the sentence that starts with there and ends with Ms. Lombard. The question is, how did you come to that conclusion?
Well, I think the facts, I think there's a consistent and a coherent and a logical sequence of events that has been, the judgment was also clear on that. There was clearly knowledge that Joshlin, would be sold and that there's money involved. So yes, I think the evidence was clear in the trial and in the judgment, my lord. I would just augment that and say, I think I've mentioned it earlier in the report as well. If in some universe of different circumstances, one of these accused decided hypothetically not to partake or posed a threat to this scheme, there would have been a very, very different set of facts on the table that we would have interrogated this morning. So, yeah.
Doc, can you repeat the last part of your answer? I didn't get it.
If in some universe or different circumstances, one of these accused decided hypothetically not to partake in the scheme, it would have been very different on the circumstances we discussed this morning. Now, I didn't read the last part from the screen, but that's what he said. It comes through clearer on the transcript and sometimes the audio, because it's recorded directly from Dr. van der Wast's device into the Teams platform. Yes, thank you.
You are not in court during the trial, and I'm not opening the trial at this stage. Accused person before this court has been already convicted. If we were finished with the heads of arguments from the defense side, I suspect you'd be giving a different answer to what you've just given. It's just that you are only having heads of arguments from prosecution.
Ma'am, if I may respond, I've got the judgment. I think the judge made his judgment, and the sequence of events, the definition of trafficking was the parameters that was used. So that is what I worked with for this report, ma'am.
But you didn't work with the heads of arguments from the defense. You don't know what the defense has submitted in their heads of arguments. So your opinion and your report is one-sided. It's only the story of the prosecutors.
Ma'am, my reference is the judgment. I mean, they were convicted on the crimes of trafficking persons and kidnapping, and that is what the court found. The heads of arguments that I studied, and the summaries of the witnesses accords with the judgment, and that is what I used to compile the report, ma'am.
We are saying the same thing.
No, we're not. Because tomorrow when you're going to argue, I'm going to ask you, if you refer me to a case, to also take me to the heads of argument of counsel in those cases. Because unlike in the old days where in the old law reports you had the argument summarized, under the new style it's not there, but you've asked the question, he's answered the question.
Doc, you are saying...
Any further questions on heads of argument, I'm going to disallow, because you've asked it not only once, more than once, and it's been answered more than once.
Doc, I agree with you.
Are you? I can't hear you.
I agree with you. The documentation you used is one-sided.
I told you I'm going to disallow the question, and it's disallowed.
Thank you, my Lord. Doc, I appreciate the manner in which you are describing how trafficking might look like in general. But in this case of Joshlin, you have no direct knowledge of the victim's experience, no confirmed evidence for that matter. Having said that,
is that a question?
No, Dr. van der Walt, the question seems to be coming. Just hold your horses. Yes, I'm waiting for the question too.
I was interrupted, my lord. I will start the question from the start.
Yes, you may.
Doctor, I appreciate the manner in which you are describing what trafficking might look like in general. But in this case of Joshlin, you have no direct knowledge of the victim's experience, no confirmed evidence. What is your comment to this statement?
Well, I'm going to say the following. I've got the judgment. South Africa's packet was used, but I will just overlay that with the following. So over a 23-year period, having worked with countless cases, I've mentioned hundreds of victims of trafficking, probably equal number, if not more, perpetrators, convicted traffickers. And when you speak about a 6-year-old girl, just use the current circumstances on the table, these are egregious and incredibly heinous crimes. So there's an entire universe of published research that supports the court's case in terms of what human trafficking is, and my own experience, kind of the dynamic perspective on it is very, I think it's just very clear that these cases, there is just no good news story in how, the type of harm that these victims experience. I mentioned also, I won't go into some of the research and etc., but I think there's enough information that goes beyond the judgment in terms of what happens to these victims, well documented and coherent and consistent themes and patterns in terms of the egregious harms that befall victims of trafficking, especially when we're talking about young girl children the age of Joshlin.
I have no further questions for this witness.
Thank you. Mr. Sivenarine, are you going to be long with the witness?
Well, I'm going to speak in
Certainly. Thank you, Mr. Nkabai. Did I hear you right that you've got no further questions?
You heard me very right, my lord.
Good, thank you.
Thank you, my lord. I've consulted. I have no questions for you.
Thank you. Any re-examination?
No, thank you, my lord.
Thank you, Dr. van der Walt. Thank you for the effort put into the report. And it seems to me that at least we got service out of you as a South African, and the taxpayer doesn't have to pay you for it. Thank you so much for the effort. I can see a lot went into it, and keep up the good work. Thank you, and you can now safely go and to your appointment. You don't have to come back to us. Thank you so much.
Thank you, my lord.
Right, so it's 10 to 1. 10 to 2, 2:30, lunchtime. Between now, 2:30. So you can ask Mr. Peterson, sense his attitude to be here after lunchtime. It seems to me today is the day that people want to show attitude to me. I'm up to the challenge. Then we're going to proceed. Your witness, Mr. Kabaya, has the witness arrived? So just check during the lunch period, because if Mr. Peterson is not going to be long, we might sit later, then deal with the witness, because you said the witness was coming from Cape Town this morning. Then we can finalize all the evidence maybe today, and then just have the arguments tomorrow, and then finish the arguments, and then I can go and work on what I need to work on. So we're going to take, Mr. Adams is going to show me his time. We're going to take 38 minutes now as a lunch break. We're going to come back. We might sit late to see whether we can finalize all the evidence today. Warrant, you'll help me if we sit late? Because I know you're the one that does it, have the long drive. Thank you. Court adjourned. chasing you around. And I know that I heard from correctional services how you ran up and down to the prison and made all the efforts. It's appreciated.
You're welcome, my lord.
Thank you.
Thank you, my lord. Mr. Peterson, switch on, switch on, switch on. Thank you, my lord. Mr. Peterson, can you please, for record purposes, state your qualifications and experience?
I have been a social worker for the past 16 years. More than 5 of that 16 years was as a probation officer. I therefore hold a bachelor's degree in social work as well as a bachelor's degree with criminology.
And is it furthermore correct that you are still employed by the Department of Social Development, more specifically in the Western Cape?
That is correct, West Coast.
West Coast, stationed at the Vredenburg office, is that correct?
That is correct.
Right. And in this instance, you received requests to compile probation officers' reports for the 3 accused before court from the registrar coming from the High Court. Is that correct?
That is correct.
And did you in fact compile those 3 probation officers' reports?
I have.
You have also supplied those reports to us, and they have been distributed to all of the parties. So I'm going to ask you to start with the first one. That will be accused number 1, Mr. Jacquin Apollos, and then take us through the process you followed and then also your report compiled.
Of course, insofar as it relates to Mr. Apollos, there's the updated one with the corrections. Both of them were dated yesterday. The one has 8 pages and the other one's 7 pages. And the one was signed, co-signed by Ms. Jordan, and the other one was co-signed by Ms. Kuhn. So you can indicate which one of the two.
The one signed by Ms. Kuhn.
The one signed by Ms. Kuhn. So that's the one that I placed slightly lower in my file. So that's the one that consists of 7 pages, just for the parties, so that we are all on the same page. Yes, thank you. You don't have to read the introduction for all of the reports, but I think for completeness, Ms. Swanepoel already asked you about your qualifications, etc. But you can start with paragraph 2.
The sources consulted.
Yeah.
Will do. The sources I have consulted was with the accused, Mr. Jacquin Apollos, the co-accused, Ms. Joshlin Smith. I also spoke with Mr. Apollos' children's grandmother, the maternal grandmother. She's Ms. Hendrika Plakis. I spoke with Ms. Smith's maternal aunt, Priscilla Collier, and I spoke with the accused or the offender, Jacquin Apollos' own mother, Ms. Margaret Abrams. Mr. Apollos' family is composed of his mother and father. He has an older sister, Monique Apollos. He has a younger sister, Brittany Abrams, a younger brother, Marco Abrams. He has a daughter, Janisha Plakis, who is now 11 years old, and another daughter, Joshlin Plakis, who is 5 years old. The family and social background of Mr. Apollos reads as follows. The offender was born and raised in Saldanha. He is one of 4 children born out of his parents' relationship. Though both his parents are alive, they had become separated in 2004. This, however, does not appear to have scarred the offender in any way. His father had lived in close proximity after his parents' separation, and they therefore continued to have a relationship despite the parents' differences. The offender later entered into a romantic relationship with the mother of his children, Joshlin Smith. However, the relationship turned sour when they both turned to the use of illicit substances, which not only derailed their relationship, but it also destabilized both their lives. Later in his life, he met the co-offender, Raquel Smith, through a mutual friend with whom they both used crystal methamphetamine. Their acquaintance soon developed into them setting up an informal structure in the Middelpos informal settlement where they embarked on a cohabiting relationship. In terms of the housing and environment where they found themselves, prior to the offender moving in with his now former girlfriend, the co-offender, Raquel Kelly Smith, he had shared a 3-bedroom house with his mother, younger sister, and maternal uncle. The home is equipped with electricity and indoor plumbing and is situated within walking distances of the local public clinic, the public transport route, as well as public schools. The residential area where the offender resided with his family and later with Raquel Smith suffers under the scourge of social evils, which includes unplanned pregnancies, social ineptitude, school dropouts, and drug and alcohol abuse, amongst other social pathologies. He had been residing with Raquel Smith and her children in an informal dwelling for the best part of a year prior to their arrest and incarceration. In terms of Mr. Apollos' work history, the offender had been employed at Sea Harvest for a period of 2 years, from 2012 to 2014. He had also for some time been employed at an oyster farm in the Saldanha Bay area. His education: the offender left school after completing grade 9 at Diazville High School in Saldanha. He ascribes the termination of his schooling to his association with negative peers. Though he entered the West Coast Technical Vocational Training College in order to further his education, this pursuit was thwarted by his association with unsavory characters and his use of illicit substances. His drug use: the offender admitted to smoking dagga, mandrax, crystal methamphetamine, and imbibing alcohol. Though he had known the co-offender, Stevino van Rijn, all his life, the relationship was relatively recently cemented through their collective drug use. His physical and mental health: Mr. Apollos is reportedly in good physical health. He does not seem to suffer from any psychological issues, but fears the consequences of the current charges against him. Behavioral patterns: the offender is described by both his mother and his children's maternal grandmother, Hendrika Plaatjes, as someone with acquired and reserved character. Though he had dropped out of school early, he was never troublesome and had in fact engaged in club rugby and had conducted himself within socially acceptable norms. However, when he began to use substances with his former girlfriend, his life spiraled out of control. He is described as someone who is susceptible to influences. He is rarely rude or disrespectful towards others and is in fact, according to his mother, a pushover. Though he had clashed with the law before, it would be an exaggeration to describe him as engaging in criminal activities habitually. The circumstances during the commission of the offence and circumstances affecting the offender's behaviour. Mr. Apollos admits to having been under the influence of crystal methamphetamine on the day of Joshlin Smith's disappearance. On that day, as has happened many times before, he was charged with supervising Joshlin. As was usual, Joshlin had gone out playing after returning from school. Her mother had returned home for lunch, during which time he, Raquel Smith and Stevino van Rijn smoked crystal meth before Raquel Smith returned to her place of employment. They were thus all three under the influence of crystal meth on the day in question. He, however, continues to deny any involvement in Joshlin's disappearance, but he, like the co-offenders, are at a loss to explain how they were found guilty. In terms of Mr. Apollos' criminal record, his SAT 69 record reflects that he had been arrested for theft in 2020 and for violating the Marine Resources Act in 2021. He is, of course, found guilty on a charge, on the 2020 charge of kidnapping and human trafficking. Because the undersigned or the probation officer did not have any contact with the victim, the emotional impact it has had on her could only be speculated on. My evaluation.
Can I just take you one step back?
Sure.
At paragraph 11, the contents there, was that gained from Mr. Apollos?
Yes.
Thank
Yes,
you.
madam.
My Lord, and whilst you have interrupted the witness, may I please just ask, with regards to paragraph 12, the criminal record,
Yeah.
where did you obtain this information from?
That information was obtained from the South African Police Services Record Center in Vredenburg.
So did you have the physical SAP 69s available?
I do have it with me, yes.
I have to deal with this, my Lord. What this indicates in the report is a theft conviction and then also violating the Marine Resources Act on a CAS 2 of 1121, although that is not reflected in the SAP 69s that was signed, agreed to and admitted into evidence. So that's the reason why I'm asking this. I have to ask.
What often happens, and it's of no moment because it's not a relevant type of offense, but just speaking from experience, what often happens is that it might not be on there because it was maybe a fine paid or something like that, and so it will reflect in the police's, the local system, but not on the national base because the fingerprints were sent through.
Thank you, my Lord. I just had to.
Things like that happen, and if it's a Marine Living Resources Act, it was in all probability a J534.
Indeed, my Lord. Indeed, I accept that.
So, but I think because of the time constraints, Mr. Peterson's easiest route was go to the local people and get it there.
Thank you, my Lord. Thank you, Mr. Peterson.
It's of no moment.
No.
Thank you. I'm sorry we interrupted you. You were at paragraph 14.
That is correct, the evaluation. The undersigned finds the offender, Jacqueline Apollos, as someone with an easy demeanor. He is by all accounts a respectable individual who is considerate of others, helpful, and who had a good rapport with not only his own children but also with Joshlin Smith's children. Had it not been for his addiction to drugs, he would have lived his life in a stable, law-abiding manner. It is, however, deeply perplexing that he remains resolute in the professing of his innocence, despite the court's finding to the contrary. During his engagement with the probation officer, he had been visibly emotional when it was relayed to him how Joshlin must have been traumatized. He was very close to tears upon being reminded that he has two girls of his own and the effect it would have on him and his children if the same disaster were to befall them. He was further reminded of the Saldanha community's outrage and that people deserve to know the truth. Though this moved him emotionally, he continued with obdurate silence, insisting that he cannot explain one way or the other as to what happened to Joshlin. In describing the events that transpired on the day, Mr. Apollos reported that Joshlin had been to school. However, it is a known fact that Joshlin had in fact not been to school that day. He was thus caught in a lie. Though the lie was pointed out to Mr. Apollos, he stared back at the undersigned in stupefied silence. It thus seems that for reasons which the undersigned cannot fathom, the offender is withholding the truth. He has also not been charged with a violent offence before, and of the 3 offenders, he is the only one who had been visibly emotional during the interview. Miss Priscilla Collier, who had known Raquel Smith throughout her life, attested to Raquel's penchant towards manipulation. It is therefore quite possible, if not likely, that Mr. Apollos had been manipulated. The sentencing alternatives in terms of a suspended sentence. Imposing a suspended sentence upon the offender would be wholly unacceptable. In the light of the brutality of the offence, a suspended sentence would not be justified. This would allow the offender to live his life in relative freedom, while the life of a vulnerable child who depended on those she trusted for protection is no longer free to live her life. Therefore, in the light of the seriousness of the offence, a custodial sentence is the only one which would justifiably be a suitable sanction. Though the offender and his co-accused has had numerous opportunities to take the court into their confidence, they had steadfastly refused to disclose the truth. On the other hand, the outrage of Joshlin's family, as well as the community, would satisfy the community's demands for justice if the court were to impose the maximum penalty for this most egregious violation of one of society's most vulnerable members. Thus, in the light of the information obtained, it is respectfully recommended for the court to impose a sentence of incarceration on Jacqueline Apollos.
And you confirm the contents of the report?
I do, my lord.
Marked Exhibit SS, double S. So we can move to the report of Mr. Van Ryn.
Mr. Van Ryn.
Just to confirm, it seems to me it's 8 pages. And it's the one signed by yourself and Mr. John.
Monsieur John, yes.
This one I'll indicate now really will be Exhibit TT. Double T. So once we've done the confirmation, it will be marked as such. So similarly, Mr. Peterson, please, if you can then go from paragraph 2.
Sure. The sources I have consulted is the offender, Mr. Stevino Van Ryn, the co-accused, Ms. Raquel Smith, the file contents of the Department of Social Development, B67422 reference, the report of the late Mr. Lincoln Hartley, who was the former probation officer. This report dated the 6th of January 2017. Ms. Aisha Mostert, the sister of the offender. Ms. Hendrika Plakis, the maternal grandmother of the co-accused Jacqueline Apollos' daughters. His biological mother is deceased, as well as the biological father. They were Almarin and Andries van Ryn, respectively. He has an older sister, Board Bronwyn, but who has adopted the Islamic faith and is now known as Bahia. He has an older sister, Carly Philander. He has a younger sister, Aisha van Ryn. Sorry, it's now Aisha Mostert. And a younger brother, J.C. van Ryn. His girlfriend, with whom he had cohabited before his incarceration, is Roche Strauss, and they have a daughter together, Hope Strauss, who is about 4 years old. The family and social background of the offender was investigated, and the following can be reported. The mother of the offender was born in Paarl, but was raised in Retreat, close to the southern suburbs of Cape Town. His eldest sister, Bronwyn, also known as Bahia, was born out of a fleeting relationship between her parents. Mr. Van Ryn's parents were married on the 12th of March 1988, after cohabiting for a short time. He is the middle child of 5 children. His father had not been home as he worked out at sea for months at a time, but on the occasion when he was home, he would imbibe excessive quantities of alcohol. His father's long absences from home, coupled with the father's subsequent drunkenness, unfortunately took a toll on the marital relationship, eventually leading to its dissolution. The father's drunken proclivity created domestic instability in the household, but reportedly this did not have a negative effect on the offender as reported by himself. A former probation officer stated in a 2017 pre-sentence report that the offendant's mother had adequately managed the household after the dissolution of her marriage. Furthermore, though the strain and strife in the marital relationship were experienced by her as challenging, it nonetheless resulted in an increased closeness between her and her offspring. Mr. van Ryn disclosed that his father had never assaulted him or his siblings or their mother during his bouts of drunkenness. However, his father had, during drunken rants, damaged furniture and household items, but this never bothered him. He had always been close to his father despite his father's drinking and was emotionally affected by his father's untimely death. He reported, however, that he had, over the years, overcome the emotional turmoil he experienced at his father's death, who was murdered by a close friend of his on the 29th of April 2010. His mother never remarried. She passed away in 2023. Mr. van Ryn and his girlfriend, Rochelle Strauss, had cohabited for a period of about 5 years, not 4 years, as indicated in the report, my lord. One child was born out of the relationship, Hope Strauss, who is now almost 5 years old. The housing and environment situation was that the residential area where the offender had resided, like most townships, suffers under the scourge of social evils, which includes unplanned pregnancies, social ineptitude, school dropouts, and drug and alcohol abuse, amongst other social pathologies. He, his girlfriend, and their daughter shared a 2-bedroom house which provided them with sufficient privacy. In terms of his work history, the offender had for most of his life not been involved in the formal labour market. However, during periods of sobriety, he had attempted to pull his life together by obtaining formal employment. On those occasions, he had been employed as a gardener, had been employed at Cape Town Fish Market in Langebaan for some time, and had reportedly also been a bartender. His education: Stevino van Ryn completed grade 6 at Deersville Primary School in Saldanha. Unfortunately, during his final primary school grade 7, he began associating with peers who influenced him negatively. During that time, he took to experimenting with mood-altering substances. That experimentation resulted in him losing motivation to complete his schooling. Religious affiliation: the family identifies as Christian. However, the tenets of the Christian faith had never been a decided factor in Stevino van Ryn's life. He had, however, been baptized as a child. His drug use: Mr. van Ryn disclosed his abuse of dagga, mandrax, colloquially known as buttons, and crystal methamphetamine. Physical and mental health: the offender is reportedly in good physical health. He had been stabbed with a knife on 3 separate occurrences, but this had not affected his health. He had performed adequately in primary school until he began using mood-altering substances. There is therefore no reason to suspect a cognitive deficit. Behavioral patterns: the offender took to experimenting with substances in early adolescence. This has resulted in him losing interest in school, subsequently leading to him terminating the schooling out of his own accord. This has left his mother alarmed and worried for his future, as she had always placed a high premium on educating her children. Though the offender had never been a gang member, he had since adolescence associated with persons who had a positive attitude towards crime and criminality. This unfortunate turn of events came about immediately after his father's death. His sister, Aisha Mostert, as well as the maternal grandmother of his co-accused children, Jacqueline Apollos, described the offender as someone who is easily provoked. He is said to be high-strung, with no qualms to assault persons who angers him. Previous interventions, Stevino van Ryn had been afforded opportunities to turn his life around on several occasions, but he chose to continue on the negative trajectory his life had taken since early adolescence. My Lord, I must just pause here, because like the previous accused report I've read out, this information that I got from his SAB 69 is also not completely the same. Yes. Yeah. The SAB 69 I have, however, showed that he was convicted of robbery in 2014, again of robbery in 2016, violating the Drug Traffic Offences Act in 2018, and for housebreaking in 2020. That's right.
The other arrests, he was not convicted in all of those charges.
It would seem to be the case, my Lord. Yeah.
And that included a charge of murder in 2022.
Yeah, that is correct, my Lord. He is, of course, like the previous accused's report I read out. Has not been found guilty. He is currently found guilty on a charge of kidnapping and human trafficking. In terms of my evaluation, the inquiry surrounding Stevino van Ryn's upbringing and personal circumstances revealed several risk factors emanating from his early teens. That is, associating with unsavory characters, the use of illicit substances, and potentially the death of his father, which left an indelible negative mark on his development. Thus, despite being raised in a home where positive moral values were inculcated from an early age, the offender nonetheless succumbed to factors external to the family. It should therefore be noted that early school living, substance abuse, and the negative community aspects had contributed to him behaving contrary to social norms and functioning outside of the law. However, Stevino van Ryn had been granted several opportunities to turn his life around, which he had flouted carelessly. He himself had acknowledged that his father's untimely death had impacted negatively upon him, but he is no longer a child and has the maturity to understand the errors of his ways. He has been described by both his sister and Mrs. Plaatjes as someone who is easily provoked, and in the light of his many infractions, he is clearly a menace to society. Moreover, the offender flatly denies any culpability in the matter. He acknowledges his substance abuse but continues to deny any involvement in Joshlin Smith's disappearance. In fact, he professed his innocence continually and blames the police for falsely accusing him, accuses the witnesses of lying, and the judge of being biased. The undersigned can therefore find no room for mercy or absolution. Leniency is further thwarted by his complete lack of remorse. In fact, upon questioning, he carelessly stated that he does not care what happened to Joshlin Smith. In terms of the sentencing alternatives, I have to repeat that a suspended sentence would therefore, in this matter, be completely inappropriate. The offender has throughout his life demonstrated a propensity towards crime and criminality. His propensity towards criminal activity, in addition to the egregious nature of this offence, would harm the faith of society in the criminal justice system if a suspended sentence were to be imposed. Therefore, a custodial sentence, in the opinion of the undersigned, would therefore be highly appropriate, given the age of the victim and her inherent vulnerability. Thus, in the light of the seriousness of the offence and the offender's apparent lack of remorse, the undersigned, in his considered opinion, finds that a custodial sentence would be the most appropriate sanction. Not only will it send a clear message that the courts will deal harshly with such matters, but that the life of an innocent child warrants the most severe penalty possible. The probation officer could find no redeeming qualities in the offender. He has a propensity toward criminal activities and is therefore a threat to society at large. Furthermore, as I already stated, the offender had not shown one iota of remorse.
And then you make the same recommendation.
Yes.
As with Mr. Thomas. Will you confirm the contents of the report?
I do, my lord.
Peterson?
Yes, I do.
Thank you. It's saying marked Exhibit T, double T. We now turn to the report in relation to Ms. Smith,
So I'll also start with this.
which we will mark ultimately as UU.
As the court please.
And similarly, I take it the introduction is the same with your qualifications and so forth, and the employment. So we can start with paragraph 2 as well. Thank you.
Correct. The sources I have consulted is, of course, the offender, Ms. Raquel Smith. I also have consulted the report of a colleague of mine, Ms. Jarrell Benjamin, the report that she had compiled in 2018, dated 8 August. I'm also referencing Mr. Cas van Zyl, who was a psychologist at the Namakwa Treatment Center in Vredendal when she was sent there in 2018. The file contents of B618651 reference, her maternal aunt, Ms. Priscilla Collier, and Ms. Janae Moss, who is a social worker at the Siyabonga Shelter for Abused Women in Vredenburg.
Can I just pause you there?
Sure.
So the file contents of that B6185 or 18651, we already heard about that contents in the main trial by your colleague.
That is correct.
Good.
Her biological mother is Amanda. I neglected to put in the mother's married surname, which is Daniels. She has a biological father, but she was primarily raised by her grandmother, which is Rachel Smith. What I did not, just to pause here, my lord, I didn't put into the, no, I did, I'll get to it later. Okay. She has a daughter, Joshlin Smith, a son, Requin Smith, and another daughter, Rochelle Smith. Ms. Raquel Smith's family and social background. The offender, Ms. Raquel Smith, was reportedly born and raised until the age of about 12 in Springbok in the Northern Cape Province, after which she relocated to Saldanha Bay. Reportedly, she suffered rejection by both her biological parents and was raised by her maternal grandparents. This was pointed out by her maternal aunt Priscilla Collier as a blatant lie. Raquel was in fact legally adopted by her maternal grandparents as an infant, but has had contact with her mother, biological father, and stepfather throughout her life. Ms. Raquel Smith later, when I read out the report to her, she said to me that it's not true. She's never had contact with her biological father. Then, to continue, her mother had 4, not 3, more children. According to Ms. Smith, this had left a negative impression on her as she struggled to process how her mother could, as she described it, turn her back on her, but not on her half-siblings. This statement given by Raquel Smith was, however, found to be a fabrication. Her mother was only 17 when she gave birth to her, who later married and has had 4 more children with her husband. Raquel Smith was never rejected by either her biological parents and was in fact supported emotionally and financially by her biological parents, maternal grandparents, and stepfather. Furthermore, Ms. Smith claimed to have been a victim of sexual abuse when she was 13 years old or thereabouts, which according to her had caused her great unhappiness and emotional upset throughout her life, a claim which was dismissed by her grandmother as well as her aunt Priscilla Collier. Raquel Smith had been romantically involved with Jose Emke, her daughter Rochelle's father. Reportedly, the relationship was characterized by domestic violence, which prompted her to seek relief at a shelter for abused women in Vredenburg. That relationship was terminated in 2021. The offender had later been romantically involved with a co-accused Jacqueline Apollos for about a year at the time of her daughter's disappearance. Housing and environment. The informal settlement where the offender had resided with the co-accused Jacqueline Apollos suffers under the scourge of social evils, which includes unplanned pregnancy, social inaptitude, school dropouts, and drug and alcohol abuse, amongst other social pathologies. They had been residing together for the best part of a year prior to their arrest and incarceration. The informal structure in which she had lived offered little in the way of privacy due to its highly restricted living space. In terms of work history, Raquel Smith had been employed at various locations as a cashier and also as a domestic worker on the West Coast. Her education, she completed grade 12 at Diazville Secondary School in Saldanha. In terms of her drug use, Ms. Smith first engaged in the smoking of dacha, which later escalated to crystal methamphetamine. Onset use started in adolescence over weekends for 15 years according to her application to Namakwa Treatment Center. She entered that treatment center on 30th of August 2018. She was discharged on the 11th of October 2018, but relapsed soon after being discharged. It appears that Ms. Smith has been struggling with drug-related problems such as the use of methamphetamine and cannabis for the past 20 years. Physical and mental health. The offender is reportedly in good physical health, except that she has a history of asthma and was relatively recently diagnosed with hypertension. Raquel Smith was regarded as suffering from mild depression in 2018 by a psychologist when she entered treatment for substance dependency. During her treatment period there, she was also reported to have suicidal ideation, that is, thoughts about suicide, and recently complained about having trouble sleeping. Behavioral patterns. Raquel Smith presented with some behavioral challenges when she was on high school. Though she managed to complete a high school career successfully, her behavior took a turn for the worse when she began to use drugs regularly, resulting in threats of physical assault against her grandmother as well as her children, or child at the time. This turn of events prompted her grandmother to evict her from her house. In February of 2016 already, it was reported to the officers of the Department of Social Development of the offender's propensity to hurl abusive language towards her eldest child and threats to harm him physically. At that time, the maternal great-grandmother of the child, that is, was the primary caregiver of the child, Requin Smith, not Joshlin Smith, Requin Smith. The great-grandmother and aunt had complained of Raquel's substance abuse and negative behavior. Priscilla Collier gave an account of Raquel's heavy-handedness in disciplining her children, whom she would not only frequently slap around their heads and body when angry, but threatened them with physical assault and verbal abuse in crude language. The women's shelter social worker Janae Moss, however, reported that Raquel had shown great care to Joshlin during their stay at the shelter, but this may only be because she had been surrounded by others, including carers and a social worker, and was not abusing substances during that time. But she had nonetheless and habitually abused her relatives, both verbally and emotionally, often swearing at her grandmother and Aunt Priscilla in crude and vile language. Her drug abuse over many years had alienated her from her family, including her grandmother who had raised her, and damaged her relationship with her biological mother. The offender attempted to bring the undersigned under the false impression that she had suffered rejection at the hand of both her biological parents. This, however, proved false, as she has had regular and meaningful contact with both biological parents, but as stated earlier, she now says not with her father, as well as her stepfather, who had in fact gone out of their way to assist her in finding employment and to set her on a steady path. Circumstances during the commission of the offence. Ms. Smith admits that she had been under the influence of crystal methamphetamine on the day of her daughter's disappearance. She further admitted to obtaining crystal meth for the use of herself and the two co-accused. They were thus all three under the influence of crystal meth on the day in question. Ms. Smith, however, continues to deny any involvement in the disappearance of her daughter. She accuses the court of being biased, her legal representative of being incompetent, the witnesses of lying under oath, and the community of being misinformed. She merely speculated, when she was interviewed that is, that her daughter could be trafficked as a sex slave, but she believes her daughter to be alive. Previous interventions. Opportunities have been provided to the offender in the past, including referral to a rehabilitation centre for the treatment of her addiction, which she entered on the 31st of August 2018, and was provided with shelter at a centre for abused women in Vredenburg, not only in May of 2018, but again in August of 2019. In addition, the offender was included in a family strengthening program at the Department of Social Development in December of 2023. Her criminal record reflects that she has not been arrested before. Again, in terms of the victim impact statement, the undersigned has had no contact with the victim and can therefore not report on. My evaluation. At the time of engagement with Raquel Smith, during the interview with her on 21 May 2025 at Paulsmoor Correctional Centre, she appeared disengaged and demonstrated a lack of awareness regarding the gravity of the incident. She attempted to hoodwink the probation officer with falsehoods. In the first instance, she fabricated bold-faced lies about being rejected by her parents, and secondly claimed to have been sexually abused as a child. Also, consider that the mother of the co-offender, Margaret Abrams, as well as Raquel Smith's maternal aunt, Priscilla Collier, described her as manipulative. It is therefore not a stretch to conclude that Raquel Smith is the mastermind behind the trafficking of her own daughter. It is also quite disconcerting that Ms. Smith violated her daughter's trust in her, not only as her provider, but also as her protector. The drug abuse of the accused contributed to the inconsistency of the care and supervision of her children. Although she received substance abuse treatment, she has not internalized the program's objectives. Thus, her behavior throughout was that of an unreliable adult. Therefore, it is in the best interest of Ms. Smith's remaining children to be cared for in a family environment where parental responsibility is taken seriously as defined in the Children's Act definition of care, Act 38 of 2005. In terms of sentencing alternatives, therefore, a suspended sentence would not serve justice. The egregious nature of the offence and the community's outrage will not be satisfied with a suspended sentence. Such a sanction would only fuel the community's anger, which expects the court to deal decisively with the matter. A custodial sentence would therefore not only be appropriate, but just. The probation officer cannot find any redeeming qualities in Raquel Smith. Our primary concern during the interview with her was for herself, that is, attempting to convince the court to deviate from the minimum prescribed sentence. In addition, several aggravating factors apart from those already mentioned must be taken into account. Raquel Smith's coercion of others in carrying out the offence, abusing her child's vulnerability, using deception, abusing her power, and not least of which, receiving payment My recommendation is therefore the same as for the other two co-accused.
That is then marked exhibit UU.
As the court
and
pleases.
entered into the record.
As the court pleases, my
Any
lord.
questions from the state?
I don't have any further questions. Thank you.
Thank you, Mr. Harmse. Before you start your cross-examination, may I just ask you the victim impact statements that were circulated? Are you going to have any issues with it?
May I just turn my back quickly?
Yes, certainly. I just want to plan around the witnesses that's available.
Thank you, my lord. Yeah, no, there's no, we consent to that. No problem.
Ms. Nkabai?
Thank you, my lord. When the court is saying we're having any issues, what kind of issues are those, my lord?
Normally what happens with these victim impact statements, in this case it was prepared by the court preparation officer. So those are statements from other persons, and they normally just presented to the court. Now we know that some of these statements were handwritten statements, so that we can plan for tomorrow. It might only happen tomorrow morning. That's why I'm asking you, will there be objections to these statements as being read in? Because then we can give them overnight to Ms. Mokoena, who can then look at them. So when they read out in court, it makes it so much easier to translate them into English.
Yes, my lord. I didn't even have an opportunity to read them because they are written in Afrikaans, most of them.
Except for the language. Do you have any other issues with them, admissibility issues?
I'll have issues, my lord, because I don't know what is contained in those statements.
But you got them yesterday, didn't you?
Yes, I did, my lord.
And what plans
Yesterday
did you,
late.
And what plans did you make to have an understanding of it?
I didn't have time to make any plans because yesterday I was traveling from Cape Town to Saldanha. This morning, the court started at 8:30. I did at 9:30.
And tomorrow morning we're going to start. We didn't start at 8:30 this morning.
So I didn't have time
We
to
did
ask.
not start at 8:30 this morning.
9:30, my lord.
Because you said 8:30.
I corrected myself, my lord. 9:30. I didn't have time to ask the interpreter to assist me with the contents of those statements.
Of course, it's a mere favor that the court staff works after hours to assist defense counsel, and it shouldn't be abused. Let me just hear from Mr. Sievenarijn. Mr. Sievenarijn, what are your take on these matters?
My Lord, there is a possibility that it may be handed in by consent. I just need to confirm the instruction.
Okay. Can you, by this evening, just alert your colleagues what your stance is so that we can plan? Both you and Ms. Nkabai.
I'll do so.
Just by this evening to alert them so that we can plan in the morning
As God please.
as to how to go about it. In the meantime, the ones that are in Afrikaans, I'm going to make them available to our interpreter for the court to make it easier tomorrow.
Thank you, my Lord.
So, Ms. Boltney, I know that you're here every day, but if you then want to be excused, instead of waiting, then you may. Good. I note the name from the covering report to the statements. Yes, thank you. Mr. Harmse.
Thank you, my Lord. My Lord, may I just establish I don't really see any need to cross-examine a probation officer. However, in this instance, I have some corrections I would like to be made.
Certainly.
And then I will just ask him regarding that.
Certainly.
Thank you, Mr. Peterson, I represent Mr. Apollos. Just want to refer to your statement that you've read out now. First of all, to paragraph 11. Paragraph 11, I'm going to, in conjunction with that, also paragraph 14, but let's start with paragraph 11. My client's instructions are that he did not say to you that, and I'm going to read the third sentence, except the heading. It starts with Mr. Apollos, then the third sentence starts on the right-hand side, as was usual, comma. Joshlin had gone out playing after returning from school. My client denies that he said that to you. That is not correct, I submit, and I will, in terms of the evidence, it is very clear that Joshlin didn't go to school that day. So my client says he didn't tell you that she, after returning from school.
Would you like me to respond?
Please, what do you say?
I cannot explain why he would now say that he didn't say that to me, because that's what he said to me on Sunday when I visited him in prison. And this report was also read out to him this morning, and he didn't object to that information this morning. So it's strange to me that he would object to it now.
Sorry, just tell me, when was this report read out to you this morning?
This morning, when they came from the correctional center.
You read the report
Yes.
out to you?
You will recall, Mr. Harmse, at the outset this morning, when counsel came to see me in chambers, I had indicated to counsel, and I also referred to that on record later when Mr. Peterson wasn't here, that I became aware early morning that the social workers were on site. As we were doing planning with Colonel Moodley about the arrangements, they sought permission for the social workers to drive into the facility. That's how I knew that they were here early this morning. Because she had to give special arrangements to the people outside that they can come in with their vehicle into the facilities, because only certain people can park inside. So Mr. Peterson was here early this morning.
I remember your Lordship says that.
Yeah.
Thank you. My Lord, then just before I carry on, just want to then refer to paragraph 12 as well. I take it that the court accepts that for sentencing purposes there's one conviction as per the SAB 69, which will most probably know, as your Lordship says. It doesn't make a difference.
It's of no moment. In any event, the one that's added on is that statutory offence, which doesn't even fall within one of the schedules.
Thank you, my Lord.
Yeah. So I will disregard it for purposes of sentencing in any event.
Thank you, Lord. Let's go to paragraph 14. Mr.
Can I
Peterson.
just, going back to this point at paragraph 11. So I became aware, and you were not here this morning when I spoke about the happenings on Saturday. So I became aware that I didn't know who the social worker was. Saw the names the first yesterday afternoon when I saw the reports. That you were going to go to the prison on Sunday in order to complete these reports. So when you consulted with Mr. Apollos, were you alone with him in an area?
Yes, we were in one of the wardens, I think one of the senior wardens' offices. So he was there, myself and my assistant, as well as one of the wardens.
Good. And were you aware at the time when he was telling you that Joshlin had returned from school that he was fibbing?
Yes.
You knew that?
Yeah.
Thank you, Rob.
Because it was common knowledge, especially if you're in the West Coast area, that those were the facts. She didn't go to school.
Yeah.
And there were more than one version given to different people as to why she didn't go to school.
Lord, yes, then I won't waste court's time any further because that's the same issue I had with paragraph 14, the fourth paragraph from the top, also referring to the same incident, which we all know. It is common knowledge. It's struck. Thank you.
Just to confirm, Mr. Peterson, that you were requested by my office to do these reports.
That is correct, my lord.
Not by the state.
No, my lord.
It came from us. In fact, the letter that was sent came from our office.
That is correct, my lord.
Good. And that's also why it was fast-tracked, because we wanted to finish the case. And just to explain to you, so that you were at ease, that incident of Saturday was also because it was impossible to avoid unnecessary expenditure, which would have been fruitless, because everything was planned.
I have no more questions then.
Thank you. Mr. Kabai. Mr. Peterson, we're going to try, and we might sit a bit later, but we're going to try and accommodate you so that you don't have to come back on another day.
It's perfectly all right.
So it might get late, but just bear with us.
Why the court is suspecting that?
Listen, goodbye. Do you really want to take off?
I'll prove the court wrong.
Are you going to surprise me?
Oh, gosh. Thank you, my lord.
No, listen, goodbye. I mean it seriously with Mr. Peterson. I have told counsel in chambers, and I've now referred to it twice or thrice in open court. Him and his colleagues were under tremendous pressure. It normally takes no less than 6 weeks to do a single report. That's the normal timeline. I gave them 3 weeks initially, and he had indicated it wasn't because he was lazy, because they already started working from day one. But the message I got through my registrar was they want to do a proper job. They don't want to give me half-baked stuff. And I appreciated that, but I just couldn't allow the matter to be postponed. So from that time, Saturday afternoon, I was kept abreast of that things are moving. The correctional services informing our director of court operations, yes, the social workers were at the prison, yes, they are there, things are moving. I had no contact, our office had no contact with them further. So I know they've been working under tremendous pressure. And it's not often, have you ever testified in the High Court before?
I have, my lord.
Way back.
Last year.
And
this individual
was it a pleasant experience?
It wasn't a pleasant experience.
So I also know that they would most probably be under tremendous stress because they have to come here and we've been putting pressure. So I want to put him at ease, and I don't want to inconvenience him unnecessarily. Hence I'm saying to him, if we need to, we're already long over normal court hours. So it wasn't aimed at you, but I see you took the bait. Thank you.
Thank you, my lord. Good day, Mr. Peterson.
Good afternoon.
Is this the first serious matter you were asked to prepare a pre-sentence report?
No, my lord, it's not.
Do you always recommend maximum sentencing in all your serious matters?
No, I do not.
If I'm going to interrupt Ms. Nkabaya again, I was surprised because normally the social workers go for the lesser sentences. I was very surprised to see that you have given the recommendation you gave and you motivated one. I'm not saying you're right or wrong, but normally one expects, and the public normally say, but why do they want a probation officer's report? It's just to come off lightly. Because that's how the perception.
Yeah.
And I expect that probation officers be objective when they give the reports.
Understandable, my lord.
Thank you. Yes, Mr. Kabay.
You spoke with my client. You spoke with his family members. Did you speak to any of the committee members?
No, I did not. Unless you regard these families as members of the community.
I'm referring to members of community who are not family.
No, I have not.
Any reasons why you haven't?
I didn't even follow this on social media or on the TV, but it was difficult to not pick up snippets of information because people talk about it all over the place. The community is in uproar, and so you come across conversations all the time. But I deliberately tried to avoid that because I didn't want to have a bias when I did eventually. I anticipated that the court might ask for a probation officer's report, and I didn't want to approach it from a biased place. You understand what I'm saying?
No, I don't. Can you repeat?
I didn't want to have preconceived ideas about the three offenders. As I anticipated, as I've just said, I've anticipated that the court might very well ask for a probation officer's report, and I didn't want to be influenced. I didn't follow it, but you pick up information here and you pick up a bit there. You watch TV, you go on you Google something and something comes up about Kelly Smith. So it wasn't possible to avoid it entirely. But that is my reason for not having spoken to specific members in the community.
Are you saying media has an influence?
It could have an influence.
In your report?
No, it absolutely did not have an influence.
But you watched some information here and there about Joshlin's case.
What I merely pointed out was that it is impossible to avoid You switch on the TV and there's something. You open a newspaper, there's something. You go to the shop to buy bread and you come across people talking about it. So it's not impossible to avoid it completely.
It cannot be impossible to avoid, but it can be impossible not to base your report or not to watch it in the view of basing your report on it. What is your comment on that?
Could you repeat, because I don't understand?
I'll make it clear so that you understand. You just said it. It was not possible for you to avoid what you see on TV. Is that correct?
Not entirely. It's not possible to entirely avoid what you see.
There are other parts you watched and you used them in preparation for your report.
No, my lord, not at all.
Okay, let me rephrase my question. When you say not entirely, what do you mean?
What I mean by that is, as I've stated twice already, that though I had not followed the entire saga, I made a point of not following it on social media, on TV, but it's impossible to avoid doing so completely. Because of social media, it's ubiquitous, it's everywhere. Sooner or later, you're going to see something on TV or see a cover on a magazine, or somebody has a picture in your WhatsApp, for example, as a status. So you can't avoid it, not completely. But to suggest or imply that I was in any way biased towards either of the three offenders would be wrong.
We're not yet there. Let's go back to your answer. When you say you did not completely, can you tell this court those parts that you took from the media?
Nothing. I took nothing from the media. I wanted to base my report on the information that I could obtain from the offenders and from the other sources I have consulted.
Completely, entirely. I'll leave that, Mr. Peterson. I'll come back to it later. Are you aware of any mitigating factors as far as my client is concerned?
Any what factors?
Mitigating factors.
As I have stated in my report, it is difficult for me to find mitigating factors in your client.
Why it is so?
First and foremost, his first offense occurred when he was merely 14 years old. Now I know that adolescents get up to mischief, but we have to look at the type of early offending behavior. And in this case, it was robbery, and it must have been serious enough for the court to sentence him. It's on his record. That says something. But quite apart from his immaturity inherent in the adolescent stage of development, he hadn't desisted from criminal behavior. He had continued. In fact, he has a bit of a reputation that you don't mess with him. He will beat you up, and he admitted it this morning when I said it to him. This is what I wrote in my report. He admitted to it. And he's been arrested on numerous occasions before. It is common that when we look at mitigating factors, to look at past behavior. And all his behavior so far, almost all his behavior so far, has pointed towards him having a positive attitude towards crime and criminality. If you look at recent past behavior, it is a good predictor of future behavior, I'm sorry, but Stevino van Rijn, even if he weren't found guilty on this offense, he would have offended again. I have no doubt about that.
You strongly ignored the fact that at the time of the commission of those alleged offenses, he was young. You ignored that completely.
I just admitted to it. I said I didn't ignore it. If you would recall, my lord, I had stated in my report that one is usually quite sympathetic towards adolescent offenders. But Mr. van Rijn is no longer an adolescent. He's a grown man. He knows what he's doing.
You ignored the fact that his last conviction was in 2020. To you, that is not a mitigating factor.
No. He was also using drugs, bear that in mind.
Using substance is not another mitigating factor?
No, it's not.
To you?
It's not a mitigating factor.
Can you point any evidence that suggests that my client is a danger to the community?
Yes, as I've just stated, my lord. The history of criminal offences, whether he has been found guilty or not, shows that he is positively inclined towards criminality. And in the light of what other people have said about his character and his abuse of substances, he is, in no uncertain terms, a menace to society.
Are you a judge or are you a social worker?
I am a social worker.
Okay, thank you.
But you're not only a social worker, Mr. Peterson. Don't undersell yourself. When I looked at your qualifications, you not only have a 4-year degree in social work, but you have a further degree in criminology.
That is correct, my lord.
So that would give you 7 years
Of education.
of tertiary education, at least.
Yeah, that's true.
So besides being a qualified and registered social worker with that 4-year degree, I've noticed that you have a further qualification in criminology, and it wasn't just a course, because you majored in it according to your CV. Can I just, I'm going to interrupt the cross-examination because it's a point that I wanted to come to, but I only got the document now. He was born in 1997.
Yes, Your Worship.
On the
My
15th
lord,
of
yes,
January.
yeah.
So in 2014, how old would he have been?
17. He would have been 17. Not 14, 17.
17.
Yeah.
That's when the first 2 counts of robbery was committed.
Yeah. Forgive me, Madam.
Suspended sentence and correctional supervision. In
Correct.
other words, under supervision.
Yeah.
Now we know that the pre-sentence report was for the 2020 conviction. I'm jumping, I'm going to come back to the others.
Okay.
So that was October 2014. Let's accept he was 17 years old. 2 years later, Then he would have been 19.
Yeah.
In fact, it was 2 days after his birthday. Robbery again. Then he got 2 years imprisonment. Because he didn't serve long. Because not long after that, a year later, that's when he got a fine for dealing in substances. Supposed to still be in prison. Then, 2 years after that, it says huisbrake plural. Again 2 years in prison. But 6 months later, correctional services let him out on parole, which parole was going to run till 2022. And forget about the other early release on the previous one. So on the 2016 one, he still had that because he was released on parole on a previous occasion. Then he was readmitted to serve another 407 days. It's another year.
Yeah.
And then we know that in that period there were further arrests for which he was not convicted. So between that 2018 and 2020, there was a malicious injury to property for which he was arrested. Why he wasn't charged or convicted, we don't know. An assault, 2019, a housebreaking, 2019, a theft in 2019, a murder in 2022, and a possession of a dangerous weapon early in 2024. You said your take is he's a menace to society.
That is correct, my lord.
Yes, thank you, Mr. Kabay. It's obviously an inference that I can or may not draw, because not all of those information is in your report, because you didn't have the SABC.
That is correct, yeah.
Do you agree, Mr. Peterson, that purpose of sentence includes rehabilitation?
I am, my lord.
Don't you think my client is self-rehabilitated himself
No,
in the last 5 years?
no.
Why do you say so?
Because he has just been found guilty of kidnapping and human trafficking. How does one make an argument for rehabilitation?
But also the last 5 years, we're now in 2025, the last I've checked. He was arrested in 2024.
Yes, that is correct.
But from 2020, he was in and out of prison and breaking his parole conditions. That's how I have it with Kabay on the SAP 69s. Remember, he got the 2 years. They let him out quick. And then immediately, almost a few months later, got another 2 years they let him out quick. And then, I don't know whether, let's accept the other 4 years should be 2 years, plus another 407 days that he was supposed to serve. So he couldn't have been out before late 2023, but he was charged with murder in 2022. He was charged with other things in 2024. It's nice to be rehabilitated like that.
And, my lord, he has. He was given a parole, and he didn't break his parole terms and conditions. The young man has self-rehabilitated himself.
We're going to argue tomorrow. So if you want to raise that argument, then you've got to explain to me on page 3 or 4 on his SAP 69s, where there's an endorsement that he was readmitted on the 18th of October 2021 to serve the remaining portion of 407 days due to a violation of parole conditions. It's here, and he admitted it.
I'll address the court tomorrow, my lord.
Yeah, please. I'm looking forward to it.
You testify that my client suffers anger issues. Is that correct?
Can you repeat that question?
Suffers anger issues.
I didn't specifically use the word anger, that is, anger issues. I'm saying he's aggressive in nature, he's easily flies off the handle.
Will that not equally be said to as anger management, or is having anger issues?
I don't think this stems from anger. He was quite assertive when I engaged with him. He said, for example, he was honest when he said the death of his father had a negative effect on him. But he also said it doesn't bother him anymore. So where does the anger come from? There's nothing that anybody indicated that one could say he has an anger issue. Not even he himself. He's just violent in nature, it seems.
And that came from his own sister as well.
Correct, my lord.
What would you say if someone will be easily provoked? You cannot say that is anger if somebody is easily provoked?
Yes, my lord. When you are provoked, we become angry. That is human nature. But not all of us, when we are angry, decide to take the law into our own hands. That is maturity, decency.
On that note, Mr. Peterson, my client instructs me that he was never angry with you.
No, I can't say that he became angry with me.
You testify that my client told you that he's using substance. Do you think that prison will be a better place to address substance abuse?
Well, I do know that the prisons offer programs specifically geared towards substance abusers. So he will have access to assistance or help if he wants it.
How successful are those programs? Do you have any idea?
I cannot speak for programs specifically in prison. But I do know that most people who do enter treatment centers relapse, the majority of them. Because it's not just a treatment center for a couple of weeks or a couple of months. It's not a magic intervention. A lot depends on the type of support you need, how determined you are as an individual, and how you are willing to change your own conduct in order to facilitate your rehabilitation. To reinforce the point, I'm going to make the example of an alcoholic. Even though you have not taken anything for, let's say, 10 years, you are still an alcoholic in recovery. So it's difficult to say. It depends on you yourself.
Other than my client's previous convictions, what else have you based your recommendation on?
The fact that he had absolutely shown no remorse, none whatsoever. In fact, his response that he doesn't give a damn, or he doesn't care, sorry, I don't want to add, he doesn't care what happened to Joshlin.
Was that a slip, or were those the words that were used?
Those were his exact words.
Those were his words. He doesn't give a damn.
Not damn, sorry, I just said damn.
What did he say?
He said, I don't care what happened to Joshlin. In fact, the warden's response was, damn, I guess, coat. You understand that expression?
No.
You are cold. The warden said he's cold. So, not only what he said, but how he said it. And then, of course, they are guilty. They've been found guilty. And yet, everybody insists on their innocence. So how does that reflect remorse?
So because he didn't show remorse, so he must be given a maximum sentence. This is the person who just told you that I'm innocent to this crime. How would you expect a person who's saying I'm innocent to be remorseful at the same time? How do you expect that? Please explain to me, I want to understand.
Somebody can admit or claim to be innocent and be as guilty as sin. I don't believe that he has shown remorse because he admits his innocence. And even when it was pointed out, but how could a competent court find you guilty? There must have been a reason. They still insist.
Who asked that question? How can a competent court?
I reminded him, I said to him, a competent court found you guilty. So what you are saying, in effect, then he responded and he said, everybody else is wrong. The community is making up stories. The police have beaten a confession out of them. Everybody else is wrong, just not them. They're innocent.
That phrase, competent court, came from you?
From me, yes.
Okay. So because of what you've counted, automatically is guilty.
The court has found him guilty. Who am I to say that he's not?
Okay. Just this question. About the programs and you mentioned previous convictions, you mentioned remorse. That's where you based your recommendation. What else?
As I've stated before, the long list of previous arrests and convictions, the early onset of criminal activity, his substance abuse, the continued denial of guilt, and just the frequency and the type and the type of offences that he has been arrested and convicted, the variety of offences that he has been arrested for and found guilty of. The fact that there is such a variety also says that somebody is positively attitude towards crime and criminality. And in the light of that, not just that alone, but consider that Jacqueline's children's grandma, grandmother of his 2 children, as well as his own sister, spoke of his propensity towards violence. All of these factors together says, as I've said before, Stevino van Rijn is a menace to society.
He told you he lost his father.
Yes.
At his early age. Don't you think that might have contributed?
It might have, in all honesty, it might have contributed, especially because he says he was close to his father. His sister Aisha had also said that they had been quite close, and when his father died, and I think it might also have to do with how his father died, he had lost interest in school, began to associate with the wrong type, so it might have contributed, yeah. I will concede that.
Coming to his comments, especially the one where you said he told you that he doesn't care about Joshlin, my instructions are that my client could not have said that. He's a father of a 4-year-old daughter himself. He could not have said he doesn't care about Joshlin. Those are my instructions. What is your comment?
He's lying.
Who's lying, him or you?
He is lying.
Okay. All right. Why would he lie?
To save his own skin, my lord.
Come again?
Maybe to solicit sympathy.
Oh, okay.
So you are being told, Mr. Peterson, you made it up.
Yes, that is what the defense
That's what's being suggested.
Yeah.
Mr. Peterson, I'm not saying you made this up.
So,
you might not have had...
I'm not done, Ms. Nkabane.
Oh, sorry, my lord.
So I'm going to follow it up with the same question you were asked. Why would you make that up?
I have no reason to make anything up, my lord.
No, I'm just asking you the same questions, just from the other side.
Get it?
Good. Thank you, Ms. Nkabane.
I didn't say you made this up.
Not saying you,
There might be
Nkabane. Your
many-
client says he made it up because your client says he never told him that. This morning when you read the report back to him, did he say anything about it?
Nothing, my lord. Nothing.
My client instructs me that you didn't hear him correctly. He was saying he is caring about Joshlin.
He is what?
Caring about Joshlin.
Not true.
I have 3 convictions for my client. 2 of robbery and housebreaking. You mentioned the 4th one. Can you remind me about the 4th one?
As I said, this was on the substance. Let's see what page. 2 of robbery, 1 of violating the Drug Trafficking Act, and 1 of housebreaking. That's the convictions I have. I don't know if your document reflects.
I'll tell you what I have on the signed SAP 69 and admitted by the accused in this court. 13th of October 2014, 2 counts of robbery. 17th of January 2016, another robbery. 28th of March 2018, dealing in drugs. And then housebreakings, there are 2, but not sure whether it could have been a duplication on the SAP 69s. It doesn't look like it, but those were housebreakings. So it actually, your indication on page 6 of your report is in line with the SAP 69s, except he might have given less than what he has, of what he admitted in my presence in this court. And he signed the SAP 69s on the day of the conviction, in case anybody doubts it. Yes, thank you.
From these 4 previous convictions, there's none of human trafficking and kidnapping. Would you agree with me?
I agree, my lord.
Softly. I have no questions for this witness, my lord.
Thank you. Mr. Sidner. Anybody want to take a break? Mr. Sidner, are you going to be long?
No, my lord. I'm not sure how many instructions my client has, but I'm not going to be long.
Maybe just check, because if you're going to be long, then we might take a 5-minute or so break, just to stretch.
May I approach?
I'm not going to rush you, so you can just indicate to me if you're going to say I'm going to be 10 minutes, then we push through. Because I notice it's already past 4 and I'm okay, I'm comfortable.
May I approach him?
Yeah. Thank you. I've just been told by my registrar they were prepared to be at least 8 o'clock, so they still have a lot of time to go.
Okay.
Thank you, my lord. My lord, I request that we take a 5-minute adjournment. That would allow me an opportunity to take the instructions.
Let me say it's 8 minutes past 4. Is it okay if we take it till 4:30? I suspect, when the reports are read by Ms. Smith would have seen it, but now when it was read to her this morning, or whenever that was read. And Mr. Peterson consulted last week in Polesmoor with her, according to the report. Now that it's read in open court, she might remember things, and let's rather clear that. It's not that long, it's now 10 past, so it's a 20-minute break. During that period, we will then do all the admin for the warrants and so forth. Get that out of the way. And you will have sufficient opportunity to consult.
Thank you, my lord.
Till 4:30, then we'll come. Peterson, you are still under oath. Mr. Sibnarain.
Thank you, my Lord. Sir, were all sources which you consulted mentioned in your report? And I'm talking specifically with regard to accused number 3.
So you're asking the sources that I've listed in my report whether I've consulted with all of them? Yes, I have.
Were there any other sources that are not contained in your report?
I would have liked to speak to Miss Smith's mother, but that did not happen. She is in the Northern Cape. She lives there. Biological mother, that is.
Now, with reference to paragraph 4, the family and social background, the first sentence there, it says that she was reportedly born and raised until about the age of 12 in Springbok. Who or what was your source of information there?
She herself shared that information with me, my Lord.
This was during her interview recently?
Yes, last week.
And further on, you go down to say that that was a blatant lie. What did you mean by that?
My gosh. Oh, that she had been rejected. That is a lie. As reported by her maternal aunt, Priscilla Collier.
Did you confirm whether she was adopted as an infant?
No.
My instructions from accused number 3 are that she never told you that she lived with her parents until the age of 12.
Does that paragraph say that she lived with her parents until the age of 12?
No, my Lord. The way I understood it, my Lord, it was that she was born and raised until the age
In the
of
Northern
12.
Cape. But that doesn't mean, if you look at the first sentence, it says that she was reportedly born and raised until the age of about 12 in Springbok in the Northern Cape. And then relocated to Saldanha. But if you look at the last sentence in that paragraph, it says she was in fact legally adopted by her maternal grandparents as an infant. So it could be, and it's not clear from that paragraph, that the grandparents were in fact in the Northern Cape and then moved down here when she was about 12. It could mean either or, because I recall when her sister testified on the merits trial, she confirmed that, and the social worker that testified, that she was adopted by her grandparents as an infant. That came out in the main trial. Also, insofar, seeing that we're on that paragraph, remember Mr. Peterson says that she told him that she suffered rejection by her biological parents. But again, her sister's evidence was that was in fact not so, because she spent some times there in the Northern Cape on holiday, or when they came down here, and that's when the sisterly bond also developed between the two. either when she was up in the Northern Cape or their family came down from the Northern Cape here. So maybe just to clarify that. But that's how I have it. When I read it last night, I tried to figure out this move. And because it made sense then that she had good memories of the Springbok area, a la Mr. Kutsia. Remember that discussion between them when they met at the funeral, and he specifically mentioned Springbok area, but the evidence was also her parents, a mother and a stepfather and siblings were living in Aggeneys. So then it made sense to me. There was a time where she was younger and remember the area because of that discussion. So I was just trying to figure out, reading in on the other evidence.
My Lord, I was also seeking clarification because it was not that clear to me as well. But
Yeah.
the court has assisted me. Thank you, my Lord. Now, sir, you say that you believed that it was a blatant lie when she said that she was rejected by her parents.
Correct.
Why do you say that?
Because she clearly was not. She had spent school holidays by her parents in the Northern Cape. And also she has had contact, according to her aunt, she has had contact with her biological father as well.
Which she denied this morning.
This morning she denied that, yeah.
What else in your report that you read out to her did she have an issue with this morning?
She pointed out that she had 4 more siblings, half siblings, not 3, as I've stated on page 3, which is just the next paragraph after the one we've mentioned. Let me just see if there's anything else. On page 5, she pointed out that I mistakenly spoke of Joshlin Smith when it should actually have been her son, Requin Smith.
Anything else?
No, I don't think there's anything else. Oh, of course, she denied the statement that she made about being sexually abused when she was in her late childhood, early teens. She said she never said that, and it was pointed out to her, but you did, and your aunt said that you have made the story up. She said, oh, okay, well, if that is what they say.
Can I just also, my understanding of the 3 and the 4 was that I recalled, and I didn't check it, just from my memory, that when her sister testified, she spoke about 5. And then she said, but she had a brother who passed away young. I recall when she testified about that.
Thank you, Madam. Now, so you'd agree with me that you only went through your report with Ms. Smith just around 9 o'clock this morning?
Correct.
And that you did not have sufficient time to get a proper explanation from her with regard to what she disputed or was unhappy about?
No, I think we had sufficient time. The entire report was read out to her, and I told her before I started reading the report to her, stop me if you are uncertain about anything or you want clarity, and that is what she had done. She stopped me when I said 3 children. She said, no, it's actually 4. She stopped me when she pointed out that I mistakenly spoke of Joshlin Smith when I should have spoken of Requin Smith, and she stopped me about the sexual abuse situation as well.
My instructions are that she was only able to tell you what she did not agree with and could not give you a full and proper explanation and to show you why what information you received from some other source could be incorrect.
It is for that exact reason, my lord, that I asked Miss Smith to sign the report. She wrote here, report read out to me, and she signed it.
Yes, because you asked her to just sign the report, but those are my instructions. Is that your only comment to that?
I do not know what else the defense would like me to say.
My instructions are that the aspects in your report relating to her being abusive or threats of abuse to her grandmother and grandparents is not true. Do you have any comment on that?
Look, Miss Smith has been a long-standing client of the Department of Social Development. I did not only base those statements on what she had shared with me. I went to her aunt, and also there was information in the file.
The aunt seems to reside here in Saldanha.
Yes, she does, in Saldanha.
Because she could also comment on some of the other persons.
Correct.
Yes, she will deny that she ever had a relationship with her biological parents and that she was ever abusive to anyone. And that she took any other mind-altering substance or drugs besides crystal meth.
Is that a question or a statement?
Well, I'd just like your comment on the last portion of my statement, in that she did not make use or smoke daka or any other drugs besides
That's what she said to me last week. I don't know why her story has not changed.
My Lord, may I just approach?
Certainly.
Thank you, my Lord. I've consulted. I have no further questions.
Thank you. Any questions, Ms. Swanepoel, as a result of the cross-examination?
No, thank you.
Mr. Peterson, do you have, in respect of all three persons, the reports that they've signed.
Yes, I do, my lord.
Can you maybe just arrange with my registrar, because the reports we have were the ones that were sent through on email,
Yeah.
that we just make a copy, and we can do it here, of those pages so that I attach it to the exhibits. So before you leave, she can assist you with it upstairs. And again, thank you. And apologies for shunting you around.
It's understandable, my lord. We understand that sometimes life throws the curveball, but it was an absolute pleasure.
Thank you so much, and pass my thanks also to the people in your office that assisted you. I know it was a team effort.
It was.
Thank you very much. So 8:30 tomorrow morning, will that be in order?
In order, Mummy.
Mr. Apollos, Mr. Van Rijn Smith, we're going to start at 8:30 tomorrow morning. The planning is as follows. We're going to have the victim impact statements. Mr. Kabai, is your witness local, or is there special arrangements to be made? Is the witness coming from Cape Town again tomorrow? Is the witness here now? But the witness was due to be at 11 o'clock. Any of the team driving in out from Cape Town in the morning? I just don't want to delay. How is the witness getting here, Ms. Kabai? Is there public transport? Maybe only taxis. Is there any of the persons coming from Cape Town for this case in the morning? I'm looking there at the area. Are you coming?
Yes.
Will you, and you're going to be early?
Yes.
There's a photographer in the media team. Would you be able to assist if needs be, to get the witness in? There you have it, Mr. Kabai. The gentleman with the long lens over there is willing to assist. Instead of the witness struggling with public transport to get here. And thank you so much. Thank you very much for offering. There we go. That's how a team works. 8:30 in the morning. And warrant officer, I'm sorry. You're going to get home long after dark. That's life. The court ledger.